May I, Your Lordship?
Yeah.
Lordship, I beg to mention item number 10.
I think so.
Item number 10, Your Lordship. In this matter, for respondent number 1, we have already filed our counter affidavit.
This
But,
order, we'll see the order and pass order.
but for respondent number 2, 3, 4, we are yet to file. We have not received the instruction, Your Lordship.
You are for respondent number
1, 2, 3, and 4, Your Lordship.
item 9,
No,
No.
10, Your Lordship.
10.
We have not received instruction for respondent number 2, 3, and 4, Your Lordship. So we need 3 weeks
In
time, Your
respect of
Lordship.
1, you have received.
Yes, Your Lordship. We have already filed also.
For 1.
Yes, and for 2, 3, and 4, we have not received the parawise reply. So
Okay, who is
at
for the
least 3
petitioner?
weeks time may
You're
be
there.
needed.
Okay, Ms. Ibam, Line Counsel for the petitioner, start. Ms. Pango, Line Counsel, Line Government Advocate. For submits that in respect of respondent number 1, they have filed affidavit in opposition. However, in respect of respondent number 2, 3, and 4,
Yes, Your Lordship.
the instruction is still awaited. In view of the above, see praise for adjournment of the matter for 3 weeks.
Yes, Your Lordship.
They are allowed this matter after 3 weeks.
Yes, sir. Overlies, Your
Okay.
Lordship.
Right.
Yes, sir.
Item number 5 here, right? Mr. L. Nochil will be conducting counsel and we out of the station on medical issue.
Oh, CRP.
Yes. There's a medical issue.
Who?
L. Nochil. Conducting counsel.
Oh, no, sir. Okay. So you're taking constant.
No.
Oh, the other side. No, then
Yes,
left.
I'm making.
Okay, so we'll grant, but let them also be present. We'll inform.
I'll inform you. Out of the station on medical counsel.
Okay, Mr. Ibam, Line Counsel. Submits that the conducting counsel, Mr. L. Nasir, is out of the station for medical checkup, and therefore he prays on his behalf for adjournment of the matter. He further submits that he further submits and undertakes to inform the Line Counsel appearing on behalf of the respondent. Staff, in view of the above, and as prayed for, list this matter after 2 weeks.
3 weeks. Your Lordship.
3 weeks. Okay.
Your Lordship, there's an answering of the claim.
The interim order passed earlier shall continue till the next date of listing. Okay. You inform immediately.
Yes.
Otherwise, it will be difficult.
May I, Your Lordship?
Hmm.
Your Lordship, I beg to mention item number 19 on behalf of K. Tama, Your Lordship. This mention is with the consent of the other party, Your Lordship. Kindly, this matter may be fixed after 3 weeks, Your Lordship.
Okay. Mr. Line Counsel, submits that Mr. K. Tama, Line Counsel for the petitioner, and then Line Conducting Counsel on behalf of the petitioner is out of the station, therefore pray for adjournment of the matter. He also submits that he has already informed the counsel for the other side. Staff, in view of the above, and has prayed for common list this matter after
3 weeks, Your Lordship.
3 weeks.
And there is an interim that may be continued.
Staff, Clara, the interim order passed earlier shall continue till the next date of listing. Okay.
Highly obliged.
But please, Raj. Lord,
Yes.
I'd like to mention item number 6, 15, and 16. my lord. These matters may kindly be, my lord, adjourned for 2 weeks, my lord. For some receiving instruction, and 3 are analogous matter. In fact, 6 and 16 are analogous and can be, my lord, heard
15
and
and
seen.
16
Well, 15 is not connected at all.
not connected.
Yes, 16 and 6 are
6.
connected.
Okay,
Okay.
but it has been listed.
Yes, my wrongly it's just been,
Okay, so you have an objection.
no.
Okay. Okay, Mr. Just like Line Senior Counsel. For the petitioner, prays for adjournment of the matter. For how much time you said?
May I pray for, my lord, fixing it on 24th of June, my lord?
Okay, to be fixed on June
24th.
24th.
24th, to which the Lanai Council appearing on behalf of the respondent, Mr. K. Tari, has no objection. Prayer allowed. K. Tari and Miss, okay, El Hage, Lanai additional PP, has no objection.
My lord, in
Accordingly,
item
the prayer
16,
is allowed.
Lordship,
This matter.
Item
this
number,
year has to be called, my lord.
No, not yet called.
Call, but it has not reached, I think, already charge sheeted, my lord.
Which one?
we have
Item number
received
16, madam.
information that item number
16.
Yeah.
What about 6?
Six, recently I've been instructed.
Okay, then in the 6, you write. Prayer allowed, list is matter. Is prayed for, comma, list is matter. Again on 20th June, you said?
24th, I think.
24th
24th.
June,
my lord. Lovely.
along with CRP 230, 2025. That is in item 16, that is in 6. In
Well,
the
15
6,
also can be
record
fixed
need
on
to
the
be
same
called
day.
for. On the 6, record has come. 6 and 16.
Well, the interim order passed in 16 May, can you continue?
No, Lordship.
No,
Record is not there.
okay.
Interim
Hmm,
order passed in item number 16 may be continued, my lord.
Okay,
Earlier, I think, my lord, it was called from the PS concern. And PS already charged sheeted, I think now.
see,
Because
it's,
it is charged.
still under investigation.
Yes. TCR,
It was still under investigation at that
No,
time.
it is charged sheeted lawsuit.
Now it is charge sheeted.
Yes, lawsuit. Now we have to call.
This criminal
teacher law-
petition is for quashing petition.
yes, my lord, item.
And then probably you may have to, I think, amend the prayer. Then in that case, if the case has already been charge sheeted, what do you
If
think?
the if the FIR goes, my lord, charge sheet automatically will fall through. Rather, charge sheet will help, my lord, in deciding whether the FIR could be quashed or not. My lord.
No, we do not know after filing of charge
Logic.
sheet whether whether
Logic.
the father proceeding, like
Logic.
cognizance have taken or not, charge
Logic.
frame or not, we do not know. And in that
Logic.
case, probably you may have to change and amend. Okay.
Logic.
The record,
That will
the, the office note they put. There is no office note also. It appears the record, although called for, is not yet received. In view of the above. No, record was not called for. It appears.
Lordship, we have received this information to the PS lawsuit that it is already charged sheeted.
Now, then,
Well,
in
record block.
16.
Well, GR case
16.
record may kindly be called for.
Okay, now, then, right, Miss H. Lakshmi, plan additional PP, submits that the case has already been submitted into charge sheet. Stop, para, in view of the above, call for the trial court record. Stop, para, is prayed for, comma, list is matter on 24th June. Okay, in the meantime, the interim order passed earlier, shall continue till then.
All right.
Then
Okay.
similar order will be in item 15 also. In the 15, what happened? Charge sheet filed?
Same, my lord, outcome of same FIR.
No,
Is it?
Yes.
15 also?
15 also.
Then 6,
No,
15,
15, 6 and 16.
6 and 16. That is why,
15
that is
not
for
connected.
6 and 16. I'm asking about 15.
15 is not connected at all.
Okay. Then in a 15, if 15 were the charge sheeted,
15 lawsuit, if it is
Give-
no information
15.
received lawsuit.
Hmm?
No information received lawsuit.
this is 15.
Record should call for, my lord, in this case. 15. The case diary is, my lord.
Yes, diary was called for. Record has received, no. Okay. So, then here also, pray for allowed and then list this matter on 24th, on which date the land additional PP shall produce the updated case diary.
That's it.
Okay, scan copy of updated case diary. Okay.
Obliged.
Oblige me.
Item number 1,
Yes,
By Lordship.
yes.
Lordship, this bail application
filed by the applicant, who is the wife of the accused person. In connection with the Allo case number 08/2026 under section 21 so and so, NDPS Act. Lordship, this,
It was rejected twice.
yes, the FIR, this,
Last rejection order is at
that is 12/5/2026. Case number, Lordship, 18 to 23.
12/5.
Yes,
Why,
12/5.
why this subsequent bail application?
Yes, Lordship, this is,
Although it was rejected and it is 21B,
yes,
intermediate,
yes, 21B and 20 also.
20 and 20B,
Yes, 20B is the.
and also 1A. Okay, then
Lordship, this, after filing this bail, bail application filed after charge sheet was filed before this, as Allo.
when?
It was filed on the 20.
After rejection of the bail.
No, this charge, after filing the charge sheet, this subsequent bail was filed before this dismissal just.
It was rejected.
Yes, it was rejected.
Now, how do you expect this court will consider? The trial court has appreciated, after appreciation, the fact and circumstances of the case, only it was rejected, finding prima facie case against the accused. Now he is going to frame charge against you.
Yes.
So what is the new ground that you have taken before this court?
The family members, the school going children,
School,
accused person-
Earlier also, they were going school.
now your Lordship, this,
Now, what is the new ground you have taken here?
yes, Lordship, now the applicant is also suffering from this, what,
Now, since when?
since this month. Now,
After rejection of bail?
yes, now they are having treatment and the terms so. And old mother, your Lordship, is the medical documents of the.
No, no, no. The mother, see, what about the accused?
The accused is in custody for a last.
Mother can be looked after by the family,
No, your
not
Lordship,
connected.
mother is old age, around 65 years old.
What can he make,
Uh,
can the accused make or bring her to the, make her younger?
Lordship, this,
No, no,
the applicant.
new ground, you tell me the new ground.
This, Lordship, this, now applicants, this.
What circumstances has changed since then, after rejection of the bail?
Yes, Lordship, this, now this applicant whose wife is unable to bear the basic problem of this family members. Now they
See,
have,
with
This,
see,
have 3 children.
Hmm.
One children studying at the, NF Law College.
he was found involved in another similar case also, NDPS case. How do you expect
And the Lordship, this,
when you are destroying the society?
this applicant is so
It's
suffering.
very
from this
difficult. No, no.
Abdomen pain.
No, why you have, it doesn't mean that by filing subsequent application,
No, Lordship, this,
you will accrue some right because you have made some effort. No,
this, this person is permanent resident of Dapurizo and he is government employee. And he's have animal property in the Dapurizo, so there are no chances of.
no, no, no.
This,
You have to make out, land council, knowing that unless the situation changes, you are filing one after another, disturbing the police also, calling the records.
No, Lordship, this,
And then subsequent, this was this is third or fourth?
this is not.
No, no. Within a short span of time, you have filed 2 bail applications subsequently, knowing that it will not be considered.
You know, one first bill application filed after 1 month, and second was filed after 75 days. And it was.
See the
Lordship,
case, and then your conduct, the accused, he's been found that involved in some other case also. It's very difficult. So, yes,
Well, your lordship has rightly pointed out the conduct of the accused. As of we have, it seems he have multiple cases. with
Yes,
regard
yes.
to the NDPS case.
and then see, and then he's the one, he is why, if you expect.
Lordship, he may be released on the term and condition because he's already in custody for 95 days and already charged.
He will be released on the condition that he will be in the inside the custody. He is very dangerous. It's very difficult. Land Council, you should try to understand and make convince him also that such a case, and you have committed such a case, such an offense, which may not entitle you to immediate bail. So why should you cause trouble to the police as well as to the court by filing subsequent bail application, knowing that it's very difficult?
Lordship, that now cases proceed before this, dismissal.
And then
Yes. Next is fixed for CC on the 9th of this, June.
you, after CC, you try. After charge sheet, after framing of charge, you pray for the discharge. Okay. What?
Yes,
Nothing to be appreciated because everything has been appreciated, everything has been examined, and thereafter only it was rejected.
without the application, I will press application.
Wait for some time and file fresh letter. Okay. Mr.
Tamil Lordship.
Yes, I mean, counsel for the petitioner. Praise for allowing him to withdraw this bail application with liberty to file a fresh. If so advised, this bail application is dismissed as withdrawn with liberty as prayed for. Okay.
Item number 2,
Lordship,
Yes,
this is a settlement, Lordship, in connection to passing of the
let us see your prayer.
case 13.
Okay. What is the status of the case then?
This is appearance is still, Lordship, is still.
Appearance?
Yes, the party have settled the matter, Lordship.
No. What is the offense?
Offense is Lordship,
So many.
offense is Lordship, wrongful restraint,
Okay.
wrongful confinement, wrongful restraint to extort money, criminal intimidation.
So case is at the stage of,
Appearance is stage of.
where is your prayer for
Lordship, my
the
prayer,
quashing of GR case, if it is
Yes.
registered where?
Lordship, it's mentioned, Lordship, in page number 13, Lordship.
13?
Yes.
I do not see.
Page number 13 and 14, Lordship.
Yes. Which one you want first? Read. Kindly.
Lordship, prayer, it is most respectfully, Lordship, graciously pleased to admit this petition call for the record issue notice to respond, and after hearing the party, please to set aside a quash the charge sheet number 4 and so FIR number 4 and so Honorable Court of Judicial.
You said the case is proceeded, cognizance taken. That is not in the prayer, it appears.
But Lordship, in below Lordship, in interim also we pray that only suspend the GR case number 79.
Okay,
of
that
the
is
charge
the,
sheet number.
that is the highest prayer.
Yes, Lord.
Okay.
Because
Then
parties,
not for quashing.
no, Lordship, in Lordship, in first time
Huh?
also we have prayed for quashing Lordship. It's
Where?
event.
Where,
Page
where?
number 1, Lordship.
Hmm?
Page number 1, Lordship.
Page number?
Page number 1, Lordship. In here, we have very clearly mentioned. that-
No. Then come to prayer. Come to prayer.
Lordship, prayer we have made on the only part that GR has been, number has been only mentioned in the interim prayer.
No prayer. So that is not required.
No, Lordship, it's required.
And then quashing of the cognizance taken into the case also not required. And who are the parties involved here?
I think who is Lordship, just complaint and the board of the accused person, Lordship.
Huh? Complainant and accused.
Yes, they settled the matter and for setting, causing and setting aside of this charge sheet number, Lordship, 0325, Lordship. Last occasion, Lordship, this honorable court has to produce the money receipt of the agreement.
I could see 3 persons here.
Yes, 3%. A petition.
El Tulum. Who is the complaint informant? Who are the
Is Lordship, petitioner number 1, Lordship.
number 1? And who is 2?
2 and 3 is the accused in this case, Lordship.
Accused and
Accused in this case, as per the FIR, Lordship.
2 persons
Yes,
accused.
2%, yes.
Okay, let us see the agreement.
Agreement is page number 65, Lordship.
How many persons have signed this?
See, Lordship.
Whether 1, 2, 3 have signed all of them?
Yes, Lordship. it's
Yes, show me.
Lordship, page number 67, Lordship.
Yes.
1 is Lika Tolom, 2 is Sri Bat Kile, Three is just the relatives, Lika Tabio. So, and the
No, no, no,
four is
no,
Sri
no, no.
Bataha.
Where is Likhatulum is there?
Yes, Lika Tabio is there, Lordship.
Okay, Bat Kili is there.
Yes, it's there.
And what about Bat Taha?
Bataha is also there, Lordship.
Where?
Page number 67, serial number 4, Lordship.
Serial number
4,
4. But
signature of the case on also.
he is not in the, he has signed as what?
Lordship, party have settled the issue, Lordship, on basis.
Where? This is why I could see one name. Who are the parties here? Settle Bat Khili
Hmm.
and who? And Likhatulum. And where is the name of the other? Bat Taha.
In 4, Lordship, below.
Hmm?
67, page number 67 below, Lordship. Settlement copy, Lordship. It's signed already.
Let us not adjust, just show me here. Whether he is also party who has declared.
Lordship, agreement, it is very clear. Page 60.
Okay, yes. Come to page, party's name in the agreement 65. Come.
Page 65, Lordship, may I read out? Lordship? This deed of settlement agreement is made on this 31st day of October 2025 in between Sri Lika Talam, age about 26 years old of Lika Tabio of village Ambam, post office, Yajali police station, Yachuli, Punjab district, Arunachal
Okay.
Pradesh.
He's
And-
an informant.
Yes,
And
and Sri Bat Kili, age about 75 years old of left Bat Kili of village Tago, and Sri Bat Taha,
Bat Taha is
yes,
there.
age about 30 years.
Hmm.
Same village, Lordship, Tago,
Okay.
because the petition,
They are accused.
yes, they are accused in this.
Okay. So there, you have anything to say?
Yes, my lord, the matter is came up for second time, my lord. Initially, my lord, we have raised an objection on one aspect only, that is in page number 66, my lord. The agreement clause, my lord.
Yes.
My lord, clause number 2,
Mm-hmm.
it says the second party is ready to compensate, my lord.
Okay.
Not paid, but he's anticipate to paid, my lord. So now,
We'll
my
have
lord,
to wait.
second party is ready to compensate so and so to first party expenses, advocate legal fee and other expenses. 3, that both the parties shall not use any derogatory and ill intention word against each other in near future regarding this case connection. If found to breach this agreement, then defaulter will impose 2 lakhs or 4 lakhs and case will be dealt with separately, my lord. This agreement seems to be not complete one, my lord, not sufficiently compensated yet.
Even if this court pass order also, it's likely to come,
Yes, my lord, if it is not paid.
not paid.
Lordship, we have already, this morning, additional affidavit we have filed already.
Where?
Money receipt already we have submitted,
Okay, where?
page number Lordship 70. Additional affidavit, this morning we have filed.
Additional?
Yeah,
We have not received the copy.
Where is it? No.
They have today morning itself, they have filed. It's not a part of the record now.
Saturday, Lordship, what happened, there was clause,
Okay,
because of
okay.
that, we could not be able
Hmm.
to file. Because of that, this morning we have filed. So we have original copy of the money receipt.
So if that is there,
Yes, my lord.
otherwise you have no problem.
Yes, my lord. Only the thing is,
Okay.
only the, my lord, the thing is that my lord has rightly pointed out, my lord.
Hmm.
Although, my lord, they have not impugned this cognizance order,
Hmm.
but it should be the part of the record, my lord, because, my lord, they are in criminal proceeding, my lord. There are 2 stages, my lord, which the petitioner is also aware that during the course of investigation, which will be culminate into, my lord, charge sheet. That is the investigation part. And criminal proceeding, criminal proceeding pending trial court, as and when cognizance is taken. So when they pray for, my lord, quashing of the criminal proceeding, entire proceeding, they have
Not
to,
praying, not
they-
praying for any.
yes, no such prayer is, they are just simply praying for quashing of the GR.
Hmm.
And it mean, my lord, the GR number is given as and when FIR is registered.
Ah.
GR number is given in the court
Yes.
itself, my lord, in the GR room. But so far as, my lord, cognizance is concerned, the criminal proceeding initiated as and when cognizance is taken, my lord.
Mhm.
Because there may be possibility of further investigation also, my lord. So that is the reason, my lord, the cognizance order must be part of the record, my lord.
Whether the case is, in which court the case is pending?
In the court of judicial magistrate 0, page number 69.
Is it triable by Chief Judicial Magistrate?
Yes, Lordship, all the offences are bailable, Lordship.
Bailable?
Yes,
It cannot be
it-
before the
it-
Chief Judicial Magistrate.
Lordship, in 0, only Chief Judicial Magistrate.
Okay.
Because of that, Lordship, Chief Judicial Magistrate is taking all this.
So, but he has a problem, including the prayer to quash the GR case, but then verbally, he is comfortable to make a
But
verbal
actually,
prayer.
it should be, my lord, this.
So he is praying, now he is praying for grant, beyond the pleadings.
Yes, my lord, that is there, my lord. That because, my lord, this is the standard practice. In fact, my lord, in the Supreme Court, my lord, what has
Hmm.
held is, my lord.
So what we'll do is, this time if I consider, you'll make mistake next time also. I remember you have made mistake earlier also. I think you improve. File it tomorrow, I'll dispose of. And then, wash and set aside. You make a prayer.
Lordship, it will be difficult for tomorrow because
Day after tomorrow, you take,
matter is before the honorable court.
huh?
Matter is before the honorable court, it will be difficult for tomorrow.
Difficult for tomorrow means?
Issue is lordship only that.
Yes.
the
What do you mean?
Lordship, this case lordship, thing is that only. The
No, there is no prayer.
Lordship,
There is no prayer for setting aside and quashing. How do I grant without making a prayer?
my prayer is there, lordship.
Where?
My prayer is very clear, lordship.
Okay.
It's very clear, lordship. It is in the premises, it is there,
For me, it is not clear.
lordship.
Madam PP, can we grant?
My lord, the question here is, my lord, it is well settled that the order impugned
Ah.
has to be challenged.
Yes.
Now,
that
my
is
lord,
why.
here, my lord, there may be a submission that if FIR goes, everything goes. There may be this kind of submission. But, my lord, so far as cognizance is concerned, my lord, that is the role of the, my lord, court.
Yes.
And so far as FIR is concerned, that is a part of the investigation
It's
authority.
gone. It's-
What is the difficulty in impugning both the, my lord, FIR charge sheet and the cognizance order, my lord?
So that we mention in the
Lordship,
order while
matter-
quashing.
Lordship, thing is that, lordship,
Hmm.
since the matter has been locally settled the party, before that's
Why you are here then? Settle locally, don't come here. Make a prayer, I'll grant. It's not that I'm not granting. It's for the people sitting behind also. Without prayer, I can grant, but without prayer, it's very difficult. You make a prayer, it will be granted. How do I adjust? Although there is no prayer, but this court feel grant, okay, that I can do, but then not in all case. But you will be the first person that earlier also granted. That I can't.
all right, lordship,
Hmm.
1 week time maybe.
1 week, any day, tomorrow, any one of you can,
1 week time.
any of you junior also can come. You just file, let it listed, get listed. Or what? Yeah, this week you are not here.
Lordship, 1 week time I need, because I have to collect the documents.
It's, It's number only you have to collect.
Yes.
You don't have to collect the order even. The order you have.
Lordship, I need only, my prayers need only 1 week, lordship.
Okay,
This matter after all.
Yes, ma'am.
so withdraw this
No, lordship. I will file additional that,
additional.
yes, additional.
Okay.
Yes, let them file
That
additional.
can be, okay. As prayed for by Mr. Oh, just a minute. Mr. T. Tapu, Learning Counsel for the petitioner. Some state he has not made a prayer for quashing of the GR case. Therefore, he prays for some time to file additional affidavit for incorporating the prayer.
As well as the
Yes.
necessary, my lord, the court order, impugn order.
As well as the incorporating the court, the impugn order as well as the amendment of the prayer. huh?
Yes, ma'am.
Okay. The prayer is allowed. List this matter after a week.
Yes.
Okay.
Obliged.
That's all right, lord.
Item number 3,
Hmm.
Your lordship, this criminal petition is
Hmm.
being filed jointly by the petitioner for to compound and quash the FIR bearing 107/21 and subsequent charge sheet number 42/23 also under section 498A of IPC. Your lordship, the petitioner number 1 and 2, where the
husband and wife from the year 2013 to 2022. And in the very initial stage of their marital life, their wedlock was marital life was peaceful. But
Well, what is the stage of the trial
now
case?
kindly page number 35, Lordship, Annex 9.
Yes.
This is the charge, CC order.
Number for the expo, oh,
Now the
prosecution
matter is
witnesses.
pending for trial.
trial. Okay, then where is your prayer? Let us see. Compound that can be allowed.
Yes.
Was set aside.
Prayer is given in the page number 8,
Okay.
particularly B,
Hmm.
Your Lordship.
Okay,
Quash-
where is the prayer to quash and set aside the
Quash-
proceedings?
Yes.
Hmm.
Page number 9, Your Lordship.
Yes, where?
Quash and set aside the ITA WPS number 107/21 under section 498A IPC and charge sheet number 42/23 pending trial before the Honorable Court of Chief Judicial Magistrate, UPI, Your Lordship. And there is a subsequent prayer that pending disposal of the petition, the petitioner also prays for an interim order for stay the trial of criminal proceeding of GR number 698/21 against the petitioner number 2 before the Honorable CJM UPI.
Yes,
Lordship, this is marital dispute, Lordship, only for 98, Lordship. So I have no objection, Lordship. Because as per their agreement, Lordship, they have already settled and their divorce already been granted. They have already resolved the marital status also, Lordship.
okay. Had Mr.
And Romo.
Learned counsel for the petitioner. Also had Miss
And
Hage, learned counsel, learned additional PP for the state. This petition under section 528 of Bharati Nagarik Suraksha Sanhita has been filed jointly by the informant and the accused in ETAP WPS number 107/2021. Praying for setting aside and quashing of the GR number 698/2021 arising out of ETAP WPS number 107/2021 pending before the Court of Chief Judicial Magistrate, UPI. Where is section? Under section, huh?
490.
ETA WPS number 107/2021 under section 498 within bracket capital A IPC, huh? Pending before the Court of Chief Judicial Magistrate, Learned Court of Chief Judicial Magistrate, UPI. Staff, para. The case leading to the brief, the case in brief is that on 4/8/2021, just a minute, huh? Let us clarify, huh? The petitioner number 1 is informant. The petitioner number 1 is the informant. And the petitioner number 2 is the accused. Stop, huh? On 4/8/2021, The petitioner number 1, comma, the then wife lodged complaint before the officer in charge, Women Police Station, against her then husband, within bracket petitioner number 2, alleging for domestic violence against her staff based on the aforesaid written FI, comma, the aforementioned Women PS, WPS, number, ITA WPS number 107/2021 was registered and investigated into staff. Para. Upon completion of investigation, the police has submitted the case into charge sheet against petitioner number 2 for offense under section 498A IPC. And the matter is at the trial stage before the Court of Chief Judicial Magistrate, UPA staff. Para. It is submitted that during the pendency of the aforesaid GR case, GR number 698/2021, arising out of Women WPS number 107/2021, comma, the informant and the accused as separated they are no longer staying together.
Yes, Your Honor.
Okay. Being separated, huh? Where is the separation
Page number 29, Your Honor.
agreement?
Is the order and the judgment is on page number 30.
Okay, by way of mutual divorce. Which was granted by the Lanet Court of the District Judge in TS Divorce number 61/2022, dated 21/11/2022. Stop. Subsequent, and since then, the parties are now separated and both are married with another persons and happily settled. They are happily settled and living their marriage life. Stop. Subsequently, the parties have also settled all matters, including the pending cases, by executing deed of settlement agreement dated 25/1/2025, whereby it is clearly mentioned that the informant, since separated from the accused, has no further grievance against the accused petitioner number 2, and that she does not want to pursue the matter any further. Stop. The land council for the petitioner submits that in view of the above settlement, mutual settlement between the parties, the there is nothing left, and there is no any scope for conviction in the case, and therefore we praise and for setting aside and quashing of the proceeding in proceeding in GR case number GR number 698/2021 against the accused petitioner number 2. Then Ms. El Hado, landed additional PT, fairly submits that since both the parties have already mutually resolved the dispute, and now they are staying separately, having their own spouses. And under the circumstances, there is no scope for conviction in the case, and therefore she has no objection if the prayer of the petitioners is allowed. Start of para. Then I'll record my own. Okay. Allowed, huh?
Okay.
Oblige your words.
Mm.
Item number 4,
My lord. IA number 8 may be taken.
Hmm?
IA number 8, my lord. This is for implement of my civil revision. Oh, sorry, my
I-
lord. For amendment of my civil revision.
Amendment.
Yes, my lord. Amendment application.
Okay.
Now, what happened in this case, my lord? The village authority had passed a judgment.
No, it appears that they wanted to file objection. Have you filed? No,
The last chance was given to them.
last chance.
Last order may be given. Yeah.
So no more chance.
No more chance. For 1 year, my lord, they have been taking time.
A loss opportunities. Is there any last to last?
No,
No last to last chance.
1 year has already left. Man. Last to last should include in that.
Final last also.
But 1 year has lost. My lord.
So what is your submission? No need to file. No, don't want.
Actually,
Implement or of whom?
my lord, this amendment. Sorry, man.
Huh?
Amendment of my prayer.
Oh, amendment,
Yes, only amendment,
not the implement.
not implement. Implement would be my IA number
Amendment to
7.
what? Whether they have already filed written stat.
No, my lord.
No, just
They've
me.
been taking after time after time. My lord.
Record was probably, record also probably was called for? No,
No request.
not yet. They have not yet filed any affidavit here in this case.
No, my lord.
Now amendment can be allowed,
Yes, ma'am.
Yes.
or you have no objection.
No objection.
Okay. Now see, no objection.
My lord.
Should have been 1 year back. Is it?
Yes, ma'am.
What is the, which one you want to amend?
My lord, para
What is the
23,
proposed
para 23, para 25, and prayer
of the IA?
of the main civil revision. ma'am.
No, where in IA,
IA
where
8,
you have
08, my
mentioned?
lord. Of para, my lord, yes.
Hmm?
Para it is there, my lord. In para 6, I have written. my lord.
Okay. Hard Mr. B. Teacher, learning counsel for the applicant petitioner. Stop. Also hard Mr.
T. Darin.
Learning counsel. T. Darin.
Yes, my lord.
Atlantic Council for the how many respondents are there? So,
Malab, there are original two respondents.
okay. You are representing both the respondents.
Yes, ma'am.
Okay, Atlantic Council for the both the respondent number 1 and 2. Stop, huh? Para. This is an application. This application, huh? Under Order 6, Rule 17 of Code of Civil Procedure 1908 has been filed by the petitioner seeking amendment of paragraphs 23, 25, and prayer of civil revision petition number 09 AP 2022. Stop, huh? Earlier, the learned counsel for the respondent took time to file objection. However, today he fairly submits that he has no objection if the prayer for amendment, for of the petitioner for amendment of paragraph 23, 25, and prayer portion of the civil revision petition is allowed. Stop, huh? Para. The proposed amendment are set yes, quote in the in paragraph 6, which read as under, huh? Within 6, there is paragraph. Type out the paragraph 6, huh? The proposed one, and in place of paragraph 4, when it put entire paragraph 6, okay? And that's the proposed prayer portion also, okay? Entire. Then the submission of the respondent will now come here, okay? Earlier he had objection, but now he has submitted that he has no objection, okay? For amendment of those paragraph and the prayer portion stuff. In view of the above, the prayer for amendment of the prayer above prayer for amendment of paragraph 22, 25, and prayer of the prayer portion of the civil revision petition is allowed. Stop, huh? The petitioner is allowed to amend the civil revision petition within
3 weeks, my lord.
within a period of 3 weeks. Huh? Okay. With the above, this IS stands allowed and disposed of. Okay.
Obliged, my lord.
And in the main, huh?
Obliged. My lord,
Mr. B.P. Cheftan and both, huh? Mr. Garing for respondent number 1 and 2, staff, in view of the order passed today in ISC 08 AP 2025, the petitioner is allowed to amend the civil revision petition within granted 3 weeks time to amend the civil revision petition. Okay, list this matter after 4 weeks. Okay,
My lord, one thing, my lord, one more application is IA 7, my lord.
what is that?
Now, implement of, my lord, new respondents, my lord.
Implement.
Yes, my lord.
Yeah. Here also it appears same. You have objection implement.
Yes, my lord. As per the instruction of my senior, he is on legs now, my lord. That's why.
Which one? Implement is which one? IA?
IA 7, my lord.
IA 7 is for
Yes.
implement.
Because in IA 8, we have prayed for one amendment of the prayer, my lord, because the judgment, we are challenging one judgment, my lord. Now, in that judgment, my lord, there are some parties, my lord. We have to make them as a party in this case also.
Hmm?
My lord, in my page 24, my lord, may come page 24 of my IA 7, my lord.
IA 7.
Yes, my lord.
IA 7 is for implement.
Implement, my lord. Yes.
So they wanted to file objection or what? Earlier?
Yes.
Here also they made a prayer for
Yes, my lord.
filing objection.
Yes, my lord.
Here also last opportunity
Yes, my lord.
was
Same.
given and this implement of
The parties in the case, my lord.
hmm?
Page 24, my lord. My lord, may I please come to page 24.
Who are they?
They are the parties in the civil appeal, my lord, before the district court, my lord.
Page
Page 24, my lord.
read their name.
Yes, Hogge Doji.
Hmm?
Hogge Doji, my lord. Number 1, Hogge Doji.
Okay.
Jumdak Doji.
Hmm.
Gedak Doji. Redo Doji, my lord. In page 24, it is there, my lord.
Okay. So where is the prayer?
My prayer, my lord.
Hogde Doji is already the respondent.
Yes, my lord.
Jumdak also.
Some of them are already responding.
Okay, so you are now in this IA you are praying for Gedak Doji
Yes, my
and
lord.
Redo Doji.
Yes, my lord.
Where is the prayer?
Prayer, my lord. Page 8, my lord. Page
Gedak.
8 is the prayer, my lord. In paragraph 4, my lord, I have stated, my lord.
Hmm.
Para 4, page 7, my lord.
Please. I think they are necessary party because they were party in the
Yes, yes,
trial
yes.
court also.
Yes, my
I
lord.
think there shouldn't be any objection.
Yes.
Okay, hard, Mr. BP Chairman Counsel for the applicant petitioner. So also hard, huh? Same, huh? Okay. Para. It is submitted that before the trial court in civil appeal, in the civil appeal, in the title suit also. What was this case, original case?
Original case was a Kawa decision, my lord.
Okay, Keba decision in the Keba, before the Keba also they were party.
No, my lord.
Okay.
Only in
Before the trial court in civil appeal number 03/2021, there were four respondents,
Yes, my lord. 4 respondents.
namely Hoge Doji, Jumdak Doji, Sri Gedak Doji, and Sri Redo Doji. However, you did not implement them.
Yes, my lord. In the main civil revision.
You
we
are a
have not-
petitioner. You are a petitioner.
Yes, my lord. In
It
the
was your mistake only.
yes, my lord. In the
But
main
okay.
in the main our civil revision, my lord, we have not challenged this order, my lord. Now since we are challenging this order, my lord,
Okay.
so they are necessary part.
Okay. Hmm. And however, so earlier, what order you have you
I have
challenged?
challenged the order of deputy commissioner. What happened, my lord?
In the deputy commission, they were not the party.
No.
Okay, okay. Now this civil appeal, earlier in the civil revision, you did not challenge this.
Yes, my lord.
Now, since when you are challenging this?
By way of our main civil revision.
No. In the main civil revision,
Yes.
you did not challenge this civil appeal number 3.
Yes, this is adjustment. Yes, my lord.
This was not impugned.
Yes, my lord. So by way of amendment, we are challenging. my lord.
This amendment,
Yes, my lord.
first make amendment.
My lord, yes, my lord.
This I can allow,
Yes,
will allow.
yes.
He has also now, because since it, amendment has been allowed,
If-
so let us refer the amendment.
Yes, sir.
As per the amendment,
Yes,
they are the party.
yes,
It will be allowed only, but then
Yes.
first you amend that.
yes, my lord.
Yes, Lordship.
Because
Hmm.
that would be, my lord.
No, at
Set-
one go, that, you have to first, that has to set first.
Yes, yes,
After set only, after setting that into right
yes, my lord.
in a proper way,
My lord,
then only that will be amended,
my lord.
okay?
Yes, my
But then that is not yet set.
lord.
You have to file the amendment petition first,
Yes,
and then amended, you will find that there are only 2.
my lord.
But now the impugn order, there is a 4.
Yes,
Thereafter, we'll amend again,
yes, sir.
amendment of the, or implement, okay?
Yes, sir.
Because in the main, since they were not party,
Yes, my lord.
we cannot now allow. After amendment, only this can be allowed,
My lord.
okay?
My lord. Obliged, my lord.
Next
Obliged.
question after 4 weeks, okay.
Item number 7,
Yes, no,
My lord has already heard this matter, my lord. I would like to submit only one thing, my lord. Since
Okay,
there
what
are
is-
2 Keva decision, my lord. So I pray, my lord, the original Keva decision may be called for, my lord. If the Keva decision is in their favor, my lord would be absolutely right, my lord. The
I
original
thought
Keva,
this is one,
original
the
Keva,
one which submitted by her seems the original or correct one, because in the execution order also, the EAC has already mentioned
my lord.
the order which she has presented.
Earlier also,
Yes, sure.
what I was submitting, my lord. We are very much, my lord, in dangerous position, my lord. We are relying on a secondary thing, my lord. Primary evidence we have to see, my lord, the Kabang. What is
Then,
the original Kabang decision?
Ms. Sangeeta, then it appears, because there are two
Yes, yes.
different order.
Yes, ma'am.
It appears the beginnings are same, but in the conclusion,
Yes.
there is a difference. We do not know now who has committed what. We
Yes.
cannot blame now.
Original, yes, sir.
Uh,
We
so
do not
now
want
it
to
is
cut
you
them,
who
my
is to
lord.
clarify from,
Yes.
by calling for, the original one.
Your Lordship, our petition is not about that thing, Your Lordship. We are here for the order passed by the Deputy Commissioner, Your Lordship. And Deputy Commissioner itself saying that there's no dispute, Your Lordship. And even the execution order also stated the same thing, Your Lordship. So now revoking the same thing and asking for the documents is like, Your Lordship, this
Now
is a
see,
different.
They are
Just a
hiding
minute,
something,
just a
my
minute,
lord.
huh?
Yes.
They are hiding something, my lord.
We are not hiding, Your Lordship, but our writ petition is only to the non-implementation of that order,
Now-
execution order.
They see,
My lord.
as per the executive, we have seen,
Yes, my lord.
execution order
Yes, my lord.
passed by the EAC. Probably it reiterates the order
But
presented.
that
by
has
her.
to be
Just a minute.
appreciated, my lord. That has to be appreciated on the facts that they
It
have
is
not
not-
annexed the
no,
original
and
Kabang decision
probably-
in their writ
probably-
petition, my lord.
Probably the petition is not on that.
Yes, Your Lordship.
Petition
My lord.
is not on that. The petition is against the order of the deputy commissioner.
My
Now,
lord.
even if
Yes.
this court direct also, it will be directed, direct the deputy commissioner to examine, verify, and then release only.
Yes, Your Lordship. That can be done.
Nothing more than that.
Yes, Your Lordship.
In that case, my lord, there is a civil dispute. My lord, may kindly appreciate
No.
the order of
This
the.
is not a civil dispute, Your Lordship. They are trying to give a color of the civil dispute. And whatever
Now,
they
see,
have. Yes,
if it is a civil dispute,
Yes, ma'am.
I think
They have
ought to have
approach civil
challenge.
court.
yes, Your Lordship.
ought
They
to
did
have
not
challenge.
challenge.
you ought to have challenged the order if you are aggrieved
My
by
lord.
the KEBA, as well as by the execution
My lord.
order, because in the execution, it has been reiterated, the order of the KEBA
lord,
order.
My lord, may kindly appreciate
sir.
one thing, my lord.
Hmm.
In the writ petition, they have not annexed the Kabang decision, my lord. By way of additional affidavit, they
Additional
have.
affidavit
not
only, of
taken-
course.
my
Yes,
lord.
yes.
So
But
they were
whatever,
hiding
but
something, my lord.
it is
So
there.
original record may be called, my lord.
No, why the record is necessary?
Because
Because their challenge is, they are also not pressing that it should be, the title should be decided by this court. No, we are not deciding that.
Yes, Your
The
Worship.
only what we are deciding is to verify.
Yes, Your Worship.
yes, my lord,
That
may-
can be.
the case-
Yes, Your Worship.
they can be directed to approach civil court, my lord.
No, Your,
Thereafter, if the deputy commissioner found this to be a disputed one, then he will automatically says that go for the suit.
Yes, my
Yes,
lord,
Your
deputy
Worship.
commissioner has stated, my lord.
Hmm.
My lord, may please see, my lord, page, read petition, my lord.
Now,
Page,
now probably, yes, you'll
Page
say that
25.
there is a dispute, till the dispute is settled, because
yes, Your Worship.
at that time, probably the deputy commissioner did not see the settlement by the KEBA and also reiterated by the
that is why, my lord,
Yes, sure.
the original
Execution
Kemang-
court.
original
So
Kemang-
now now since we have a copy of this KEBA and the execution, whatever may be, in
Yes,
your
sir.
favor, in her favor, it has already been settled.
Yes, Your Worship.
But then now the deputy commissioner will only verify and release.
Yes, Your Worship.
That's
Yes,
all.
Yes,
No
Your-
need to call for the record, because now we are not deciding
yes, Your Worship.
the title.
Yes, Your Worship.
Yes, ma'am.
Title according to the petition,
Yes, Your-
it has already been settled.
yes, Your Worship.
My lord, what I am
Right.
submitting, my lord,
Hmm.
after passing of final award, my lord, the
No,
deputy
no,
commissioner
no.
becomes functus
See,
officio.
Because that can also be, but then it's not required at the moment, it appears.
Yes, Your Worship.
Hmm.
My lord, now, after passing of final award, deputy
Now,
commissioner does not have any power.
In the beginning, party generally submits that record is also not necessary. Then record was not called for, and later on it comes. So it's, that is why I used to
Yes,
say,
my lord. After our,
always come
after we
prepared with
filed-
all the documents, all the records, don't hide, no, don't try to hide anything, nah?
yes, my lord. We have brought on record the original Kemang decision. Now they have brought another Kemang decision, my lord. That is the issue, my lord. Someone is hiding something.
Now,
They have not annexed in the written petition also.
supposing if the record is, even if it is called for,
Yes, ma'am.
then probably you may have to part with some amount in that case.
Yes.
Because as per the execution order, it
Okay.
has reiterated the order placed by the petitioner, not yours.
Yes, Your Worship.
That is true.
And
my
then
lord.
in that case, if found incorrect, then this court may also make an observation
Yes. Okay.
that against the person who has
And tomorrow again, we
committed
found the original,
forgery.
my lord, original copy of the.
let the deputy commissioner be assessed or examined.
Yes,
Yes,
yes.
Mm. I'll dispose of hard miss.
My lord.
Hmm. Jonglujo, like counsel for the petitioner. Also had Mr. Who is respondent number? Teacher or
1 and 2.
state is, okay. Sangeeta for respondent number 1, 2. 1 and 2, huh? State respondent number 1 and 2, and Mr. B. Picha for respondent number 3. Starting. Ara. Where is the impugned order?
It's in page number
25.
25, Your Lordship. Page number 25 of the main petition. Annexure 6.
Okay. This writ petition under Article 226 of the Constitution of India is directed against the order dated 8/7/2025 passed by the respondent number respondent number one. One is Deputy Commissioner.
Yes, sure.
Okay, Deputy Commissioner C. Yomi. Whereby and Deputy Commissioner to the extent whereby, because there are other direction also, the payment of land compensation against the stretch from Pumbum Yorlong to Taking Ling Tak has been kept at hold till the title of the land is amicably settled at appropriate forum. This is the only impugn order?
Yes, Your Lordship.
Okay. And further seek oh. Direction to release the compensation in respect of the land situated at Karle area within bracket stretch from Taking Ling Tak to Pumbum Yorlong under the area from Pumbum Yorlong to Bo Sokong bracket closed. Stop. Para. The case of the petitioner is that where have you stated that the land belongs to the Remi and Hedu tribe? They are descendant of the same, etc. Where, in which paragraph?
Your Lordship, in page number 5 of our petition, para 3.
Is
Yeah, page number 5, half para is in page number 5. It starts from page number 4 to 5.
that's the Remi clan and Hedu clan are brothers of the same descendant. And as per the custom, any property of common father are to be equally divided between the descendant of both the brothers. Stop. Where have you stated about the decision of the Kabang
It's in same page, Your Lordship. Page number 5. A copy of order dated 25/8/2023 is annexed here with,
That is order of
Kebang, Your Lordship.
Keba.
Yes, 25/8/2023. Yeah, executive order. Oh, which one, Your Lordship?
Keba. order,
Kebang, it must be in the additional affidavit, Your Lordship.
Hmm. Where did it- Additional affidavit? Okay. Hmm.
Page number 83 of additional affidavit.
It is submitted that. Who knows complaint there before the Keba?
Mm, It seems both the parties.
Okay. Okay.
Fact is that, Manoj, there was no dispute between the,
Okay.
dispute was
okay.
between someone else.
Okay, the contention of the petitioner is that by an order dated 26/4/2021, the Kebang Committee based on the document provided by both the Hedu and the Hemi and Hedu clan came to the conclusion that the land from Umbom Yorlong to Bos Sokong belongs to both brothers, that is Hemi and Hedu clan stroke community. Stop. There. However, at the time of claiming a compensation, a land compensation, Hedu clan did not cooperate and turn up. Therefore, the petitioner, being the representative of the Hemi clan, filed. Sorry, the Hemi clan, filed an execution petition before the executive magistrate, Siyomi District, Monigong, Stop. By an order dated 25/8/2023, the executing magistrate, magistrate reiterated the decision of the Kebang Committee dated 26/4/2021 and declared that and decided that in dispute, decided that in lane in dispute from Pombom Yorlong to Bos Sokong belongs to both brothers. The cell belonged to both brothers, that is Hemi and Hedu clan. Stop, huh? It is submitted that the aforesaid Kebang Committee decision dated 26/4/2021, as well as the decision of the executing court dated 25/8/2023 are not under challenge before any authority, and hence the said decision, hence the dispute, if any, with regards to the said land from Pombong Yorlong to Bos Sokong attain finality. Stop. However, by the impugned order dated 8/7/2025, the Deputy Commissioner Yomi respondent number 1 has kept Commissioner while directing payment of compensation against all the properties like house, horticulture items, etc., standing in the proposed stretch from Pombong Yorlong to Taking Lingtak for release without further delay, has kept in halt the in respect of the compensation against the stretch from Pombong Yorlong to Taking Lingtak in respect of the petitioner and the respondent till the title of the land is amicably settled at appropriate forum. Stop. It is submitted that when the matter has already been decided by the Kebang Committee, as well as by and reiterated by the executing court, and the same are not under challenge before any other authority, comma, the Deputy Commissioner, respondent number 1, ought to have decided, ought to have released, directed for release of the compensation in respect of the petitioner and the respondent, along with the others. However, the Deputy Commissioner, without appreciating that the matter has already attained the finality, has illegally kept at halt in respect of the petitioner and the respondent, kept the compensation in respect of the Pumbong Yolong to Taking Lingtak in halt till settlement, till title of the land is amicable settled on an assumption that the same was not yet settled. Stop being agreed. The petitioner has filed this civil revision, not with petition challenging the said order dated 8/7/2025 in respect of the land stretch from Pumbong Yorlong to Taking Lingtak. Start, Tara. Then I'll direct for the release. Okay. I will direct only that the Deputy Commissioner before release will examine and verify,
Okay, ma'am.
Yes, ma'am.
and if entitled, will release
By bringing,
along with that.
Yes, sure.
by calling upon the original record, my lord. The original Kawang decision.
He will do whatever is
Or the observation has
required.
been made some, my lord has
Your
made
Lordship,
some.
that
It is
examine
up to-
automatically that covered
Yes, your Lordship.
automatically
Yes.
when we direct
Mhm.
that verify
Mhm.
the entitlement
Mhm.
automatically is
My
Yes.
lord,
first
there
duty
is some
is to
dispute,
call
my
for
lord,
the
because
record
we have come up
and
with
call the
that.
party also.
Yes, your Lordship.
Okay, dispose, huh?
Kindly obliged.
Item number 8,
Just a minute, huh? Yes.
Prepared a brief list of date, my lord.
Mhm. Affidavit in opposition was to be filed.
Yes. Yes,
The file.
Already packed.
Okay, you have received the copy?
Yes, my lord.
Okay.
And here the question was, is my lord, whether my lord, after my lord decision of the first appellate forum, my lord, can again, my lord, first appeal can be filed before a civil court, ignoring the, my lord, section 100 of the CPC, my lord. Section 100 provides, my lord, second appeal to be filed before only High Court, my lord. My submission is that, my lord, two first appeals cannot be filed before a civil court, my lord. Now here, my lord, yes, my lord, can you take up my lord, brief list of dates, my lord?
Yes.
My lord will be disposing of, I think, my lord, the matter, my lord.
Or what?
My lord will be disposing the entire matter, my lord. Today, my lord.
Let us try. Or what do you say?
Well, after lordship, my lord.
The trial endeavor will be to dispose of only.
Yes, sir.
If there is any difficulty in between,
No, no, my lord.
we'll see. And if you have any difficulties,
No, no, my lord. My lord, can we take up the list of date, my lord?
Yes.
There is a list of date and a brief notes, my lord, in the facts of the case, my lord. On 22/5/2025, my lord.
This involves with the interpretation
Yes, interpretation of
and then the conflict. So one is CPC, one is the local law.
the local law.
So which overrides
Again,
or whether the local law can survive
yes, my lord.
or can this or the CPC
Yes, my lord.
overrides upon.
Yes.
So this is the question.
Yes.
So that
The
is why
supremacy of the my lord.
properly assist.
Yes, my lord. Supremacy between the my lord, law enacted by the parliament and the law enacted by the my lord, state, my lord.
Now, we have also to see that the special law,
Yes.
that the state specifically for the local,
Yes.
can the CPC.
Yes,
uh,
my lord. Here, the under the my lord, Article 254 of the Constitution in India, the clause 2 of my lord 254 says, my lord, the local law will always prevail over the my lord, the law made by the parliament, my lord.
Okay,
If it is a law made under the my lord concurrent list
so
of the
254.
Article 254, my lord. If the law under the concurrent list, my lord, the law can be made by the parliament as well as by the state, my lord. In the, my lord, the entry list which are provided in the 7th schedule of the Constitution of India. And the CPC and its procedures practices falls under the, my lord, entry 11 and entry 13 of the 7th schedule of the Constitution of India. So,
Just a minute, Entry,
my lord, entry, my lord, under the, my lord, concurrent list, my lord, the parliament as well as, my lord, the state can legislate laws, my lord, of the entries mentioned, my lord, in the 7th schedule. Here we are concerned with the, my lord, entry 11A, entry 13, entry 46, my lord. These entries relates to, my lord, laws to be made in regards to the civil procedure.
can we just see once?
Yes, my lord.
If this is clear, and perhaps we will be clear only.
My lord, yes, my lord. My lord, laws are to made under, my lord, Article 245, my lord.
Yes. 45 or 54?
54 is the repugnancy, my lord.
Okay.
54 is the repugnancy, my lord. 245, my lord.
Just a minute.
May I read, my lord?
Just a minute.
Unreadable.
Yes.
Article 245, my lord.
Mm-hmm.
Extent of laws made by parliament and the legislature of the state. 1. Subject to provisions of this constitution, parliament may make laws for the whole or any part of the territory of India, and legislature of the state may make laws for the whole or any part of the state. No law made by parliament shall be deemed to be invalid on the ground that it would have extraterritorial operation. My lord, now come to, my lord, Article 46, 246, my lord.
Subject to the provision of the Constitution, Parliament may make laws for them. Okay, then
Article 246, my lord.
46.
Yes, my lord.
Okay.
Subject matters of law made by parliament and by legislature of the state. Notwithstanding anything in the clause 2(3), parliament has the exclusive power to make laws with respect to any of the matters enumerated in the list 1 in the 7th schedule in the constitution as referred to union list.
Second, the not to hear anything contained in clause 3 parliament, subject to clause 1, legislator of state also have power to make laws with respect to any matters enumerated in list 3 in the 7th schedule in this constitution referred to as a concurrent list matter. We are to focus on this matter, concurrent list matter. Under the concurrent list, both the parliament and the state legislature can enact laws, my lord. My lord, come to 7th schedule, my lord. Seventh schedule, my lord, list 3, my lord, will come, my lord, concurrent list, my lord. Just a minute. List 3, my lord. These are the entries, my lord, the subjects, my lord, under which the parliament and the state legislature can make laws, my lord. Yes. 11A, my lord. Entry, my lord, 11A. Administration of justice, constitution and organization of all courts except Supreme Court and High Courts, my lord. Regarding the my lord, jurisdiction of the constitution and jurisdiction of the my lord, courts, my lord. And my lord, come to 13, my lord. The civil procedure code, including matters included in the Code of Civil Procedure at the commencement of this constitution, limitation and arbitration, my lord. Regarding the subject matter of the CPC, my lord, and entry 46, my lord. The jurisdiction and powers of all courts except the Supreme Court with respect to any of the matters in this list, my lord. So jurisdiction issue is also to be, my lord, can be enacted by both parliament and the state legislature, my lord. The jurisdiction and the powers of all courts, my lord. So here we are concerned, my lord, section 100 is, my lord, under the CPC, my lord, which is being legislated by the act of the parliament, my lord. Am I clear, my lord? Yes, this 11 issue of the jurisdiction can be legislated by the parliament as well as the state, my lord. Yes. Now, my lord, the section 100 of the CPC and 101 of the CPC has already been legislated by the, my lord, parliament, my lord. This is called the Civil Procedure Code, my lord, and its amendment made in 1976 as a 76th amendment, my lord. And, my lord, now the law made by the state, my lord, this is Arunachal Pradesh Civil Court Act, my lord, under the concurrent, my lord, defining the jurisdictions also, my lord. Now, my lord, section 100 of the CPC, my lord, defines the jurisdiction of second appeal, my lord. The second appeal is, my lord, can be filed from the, my lord, decree passed by the first appellate court, my lord. The second appeal will lie only before the High Court, my lord. My lord, can we, my lord, read the, my lord, section 100, my lord, for a moment, my lord, of the CPC, my lord? Yes. May I read, my lord? Second appeal. Save is otherwise expressly provided in the body of this code or any other law for time being in force. An appeal shall lie to High Court from every decree passed in appeal by an court subordinate to
High Court, my lord. Passed in an appeal, my lord. Any appeal passed in appeal by any court, my lord, subordinate to High Court, to the High Court, my lord. The High Court is satisfied that the case involved a substantial question of law. This substantial question of law was added by my lord 76th Amendment of the Constitution of India, my lord. My lord, the second appeal can be filed before the High Court only on the ground of, my lord, substantial question of the law, my lord. Now, my lord, kindly again come to the Constitution, my lord. Article, my lord, 254, my lord. The repugnancy, my lord, law, my lord. 254, my lord. May I read, my lord?
Yes.
In consistency between the laws made by Parliament and laws made by the legislature of the state. If any provision of the law made by the legislature of the state is repugnant to any provisions of the law made by the Parliament, which Parliament is competent to enact, or to any provision of the existing law with respect to one of the matters enumerated in the concurrent list, then the subject to the provisions of the clause 2, the law made by Parliament, whether passed before or after the law made by the legislature of the state, or as the case may be, the existing law shall prevail, and the law made by legislature of the state shall, to the extent of the repugnancy, is be void, my lord. So in this case, my lord, the requirement is that, my lord, the prior to, my lord, the act of the Parliament or after the act of the Parliament, there will be always supremacy of the, my lord, law made by the Parliament, my lord. But, my lord, close to provides, my lord, of Article 253, my lord, where, my lord, the state laws enacted by the legislature can prevail over the parliamentary laws, my lord. Where a law made by the legislature of the state with the respect to one of the matters enumerated in the concurrent list contains any provision repugnant to the provisions of the earlier law made by the Parliament or an existing law with respect to the matter, then the law made so by the legislature of the such state, if such state, my lord, if it has been reserved for the consideration of President and has received his assent, prevail in the state, my lord. Suppose, my lord, the state has made the law, my lord, after or before the, my lord, an existing law made by the Parliament, my lord, the my lord, prevail over the parliamentary law if the, my lord, the act has been, state act has been, my lord, given assent by the President of India, my lord.
And in our case?
In our case, my lord, I have already shown, my lord, I have again shown, my lord, the Arunachal Civil Court Act has been, my lord, given assent by the Governor of Arunachal Pradesh. It was not put before the President of India, nor it was assented by the President of India, my lord. My lord, next come, my lord. Provided that, my lord, that nothing in this clause shall prevent Parliament from enacting at any time any law with respect to the same matter, including law adding to, amending, varying, or repealing the law so made by the legislature of the state, my lord. Even after the President of India gives the assent to the state law, my lord, thereafter also, my lord, the Parliament has the power to make the, my lord, state law, my lord, redundant, my lord, repealed, my lord. Meaning thereby, my lord, in our case, my lord, the Civil Court Act, Arunachal Pradesh Civil Court Act, has been given assent by the Governor of Arunachal Pradesh, so it cannot, my lord, supersede the provisions of the CPC, my lord, regarding the jurisdiction under Section 100 of the CPC, my lord. Second appeal, my lord. Yeah. For moment, my lord, kindly see, my lord, the act, my lord, assent given by the Governor of Arunachal Pradesh, my lord. Huh? Page 140, my lord.
Yes.
This is, my lord, Governor of Government of Arunachal Pradesh, Law, Legislative and Justice Department, Civil Secretary, Itanagar. On the 12th April 2021, number law such and such, the following act, which was passed by the Arunachal Pradesh Legislative Assembly in the 6th session of the 7th Legislative Assembly and received the assent of the Governor, my lord. So, my lord, the act has been, my lord, approved on assent given by the, my lord, Governor of Arunachal Pradesh, my lord, not by the President of India, my lord. And CPC is an act of Parliament, my lord.
Okay, according to you, had
Had-
it been approved, had it been assented by the president,
My lord, then
would have
it-
override. Mm.
then this,
Okay.
my lord, state piece of legislation can, my lord, override the CPC, my lord.
Yes.
My lord, law of repugnance is clear, my lord. So, my lord, the CPC will always prevail, my lord, over the, my lord, regarding the jurisdiction, my lord, of second appeal, my lord. I am concerned with the only section 100, my lord, second appeal provision, my lord. My lord, this Arunachal Pradesh Civil Court has also, my lord, does not exactly, my lord, say that it's deemed, my lord, repealing the section 100, my lord. It is clearly said that, my lord, an appeal shall lie under section 4, my lord, subsection 4 of the section 50, and appeal shall lie from the decision of the village authority to the inter-village territorial customary court, my lord. Second proviso is that, my lord, an appeal shall lie from the, my lord, the appeal shall lie from
Inter-village.
the court of, my lord, inter-village territorial court
To
to
the
the, my lord,
civil court,
civil courts, my lord, having, my lord,
Jurisdiction.
respective pecuniary.
pecuniary jurisdiction.
So my submission is that, my lord, this, my lord, inter-village territorial customary court has both the, my lord, original jurisdiction as well as the appellate jurisdiction, my lord.
Mhm.
Because, my lord, section 40 of the, my lord, AFR says, my lord, the civil should be decided, will be decided by the village authority, irrespective of pecuniary jurisdiction, my lord, between the indigenous people of the Arunachal Pradesh, my lord.
But it appears that the intent of the legislature
Yes, my lord.
is, while making this local law,
Yes.
is that the appellate provision should be with the civil judge.
Civil. Yes,
Even after the inter-village territorial jurisdiction, customary court
Yes.
decide, the appeal lies before the civil court only.
yes, civil court.
But then it's only because it was not assented
Yes.
by the president. It lies under 100 of CPC.
Yes, that is also correct, my lord. Yes. Because we cannot ignore the provision of the CPC, my lord.
Because it appears that the intent of the legislature was only that the appellate authority for this inter-village also, village authority, inter-village, should be in the civil code, within civil code only, because it's a civil code act,
My lord.
within the civil code act, the authority within the civil code act.
That, to my, I differ, my lord, that, my lord, because, my lord, under section 3 of the Civil Court Act, my lord,
Mhm.
the classes of court has been defined, my lord.
Yes.
The classes, the 4 courts, classes of court, my lord.
Mhm.
The district court, additional district court,
Yes.
my lord, senior division, junior division,
Divisions,
then, my lord,
Senior,
customary
junior,
court,
and then the
then
customary.
the customary court.
Ah.
And the customary court is defined, my lord, which includes, my lord, village authority under section 5 of the AFR, my lord.
Mhm.
And by the explanation of the, my lord, section 3F of the, my lord, the AFR,
Mm.
the village authority includes, my lord, traditional council, the inter-village territorial
Whatever name
council,
called.
my lord.
Mm.
And this court, my lord, can decide civil suits, my lord, under section 36 of the AFR, having the original jurisdiction, my lord. And, my lord, the procedure is section 40 of the AFR, my lord. 2 conditions, my lord. The parties have to indigenous to the state of Arunachal Pradesh and can settle without any pecuniary jurisdiction, my lord. So, my lord, the inter-village territorial court, customary court, has the original jurisdiction also, my lord.
Because see, otherwise, the village authority, village council, it doesn't follow the CPC,
No,
does it?
yes, my lord. Under the CPC also it is followed, my lord.
But then, not exactly they follow the evidence, etc. They doesn't.
No, no, no. Under the, my lord, in the act of, my lord, Civil Court Act of Arunachal Pradesh, my lord. Application of CPC is not applicable to the village authority, my lord. It is only in
That is
the
why.
Civil Court.
So the first KEBA is a village authority,
Village authority,
which doesn't 100%, which doesn't apply.
yes, my lord.
Okay, and then the inter-village territorial court is also a village authority only.
Village authority, my lord.
So from here, directly coming to the High Court on the 100,
Yes.
was it the intention of the legislature? This is my just query. The intention of the legislature in legislating this Civil Court Act, it appears that from the village authority, whatever name called, be it the customary or be it the inter-village, inter-territorial customary court, the appellate authority should be civil court. The intention. Civil court, not the High Court under 100. That is what I am saying. But then, of course, what you
But,
have
my lord,
pointed out.
Section 100 says, my lord,
Hmm,
any court, my lord.
hmm.
Any court includes, my lord, inter-village territorial court, my lord. Because, my lord, court has been defined as a, under the Arunachal Pradesh Civil Court Act, my lord.
Yes,
These are the, my lord, village authorities are also court, my lord. Though CPC may not applicable, my lord,
Hmm.
but they are also court, my lord. And section 100 requires, my lord, that any appeal, the order of, my lord, any,
Second
my
appeal,
lord, appellate degree, my lord, order is to be, my lord, filed before, my lord, the High Court, my lord.
So High
From
Court
the
here
any
only,
court, my lord.
here only the substantial question of law.
Yes,
So it will be difficult. It's difficult to expect from the village authority to follow the question of law, decide strictly as per the law, as per the CPC. Then in that case, can it directly go to the High Court,
Yes,
where
my lord.
only the substantial questions of law will be examined?
Yes, my lord. Definitely, my lord.
So that
Because-
question lies, that question is
Yes,
there.
my lord.
Because here, in under 100 CPC, then only you have to decide on the substantial question of law.
Yes, my lord.
But then from the village authority,
Yes, I will take an example, my lord.
yes,
Suppose, my lord, the appellate authority, the
Hmm.
inter-village territorial council is the appellate authority, my lord. There also they examines the, my lord, evidences, my lord. In terms of, my lord, customary practices, my lord. This can be very well tested before the second appeal, my lord. Whether that, while adducing the, my lord, appreciating the evidence in terms of the customs, my lord, whether they have acted in accordance with the custom and tradition or not, my lord. That can be also be very well examined by the High Court, Honorable High Court, my lord. As a
no,
substantial
no,
question of law.
we believe that it's an appellate authority, we cannot expect that the appellate authority will examine the evidence, adduce evidence of the witnesses. Because evidence is expected to be adduced by the trial court.
Yes.
Here in this case, the KEBA, not the appellate inter-village territorial, if we say so.
My lord, appreciation of evidence is not a, my lord, condition precedent to be held as a substantial question of law, my lord.
That is true.
Yeah.
But then even then, if it file under 100 CPC before the High Court, it will formulate
The formula.
the question.
It will formulate whether
Hmm,
the evidence taken into consideration by the village authority KEBA
hmm.
was appreciated by the, my lord, the first appellate court in accordance with the customary practices or not, my lord. Not in terms of the evidence act, my lord. That's why the legislature have consciously given a scope for the blaze authorities also to try all the civil suits in accordance with the customs. Otherwise, it is also open for the indigenous parties to approach directly before the civil court under section 9 of the CPC by filing suits. The provisions of the KEVA has been kept, only to to appreciate the evidences in accordance with the custom of not under the to be appreciated under the Evidence Act. This will be examined again by the first appellate court, whether the customary practices has been really appreciated or not,
Okay. You have any authority? Sure.
I have the authority to say authority regarding the supremacy of the
Hmm.
the parliament, First, one case, under 2001 for SSC. Two 62 minor. Panino. Here, here in case, this is regarding the application of section 100 vis-a-vis the section 100 of the CPC and the section 41 of the Punjab Courts Act. Here what happened, the before the amendment of the before the 76th amendment, the law regarding the second appeal is in parity between the the CPC and the section 41 of the Punjab Court Act. The second appeal can be filed only before the High Court. In 41, section 41 of the Punjab Court Act, there was no provision for the substantial question of law. And the substantial and in including the pre-amended section 100, there is no provision for substantial question of law. After 76th amendment, in section 100 of the CPC, the substantial question of the law was included. And now the on the premises of the earlier act, the Honorable High Court has decided the matter without framing substantial question of law. This was went to Supreme Court. Supreme Court, while dealing with this matter, said that the substantial question of law was subsequently amended by 76th amendment, so it will prevail over the section 41 of the Punjab Court Act. Once the law made by the Parliament, it will be applicable. And it will be the state law will be repugnant to the Parliamentary law act. Paragraph 13 onward, May I read,
Hmm.
Article 254 thus maintains parliamentary supremacy in the matters under list 1, list 3, list 1 union list and the list 3 concurrent list. And it is on this score that that Mr. Sajjan was very eloquent that the doctrine of the implied repeal will have its true impact on the situation and thus result in a negative the effect of the section 41 of the Punjab Courts Act. Punjab Courts Act for section 41 does not require minor substantial question of law minor. Mr. Sajjan contended that section 100 of the CPC, the Code and the section 41 of the Punjab Act without any tail of the controversy have a common objective, his authority and jurisdiction to hear second appeals, and thus both operate on the same field, and by reasons of the factum of the Punjab Act being non-complementary to section 100 of the Code, it cannot but be said to be repugnant, and hence the doctrine of the repugnancy will have its full play in the matter of declaration of the Punjab Act be void. 14. Paragraph 14, on the doctrine of the implied repeal, is contended that the procedural law must be having a meaningful existence without being in conflict with the parliament legislation. Undoubtedly, the doctrine of the implied repeal is not so favored, but where a particular provision cannot be coexist or intended to subsist in the event of there being repugnancy between the central and the state legislature, the courts cannot but declare it to be so on the ground of repeal by implication. Uniformity of the law being the basic characteristic of the Indian jurisprudence cannot be termed to be a sufferance by the reasons of a state legislation which runs counter to the central legislation. It is not necessary that one legislation should be on the positive side, whereas other one in the negative side. Such a stringent requirement is not the requirement in order to bring home the issue of the repugnancy, but all the same might result when both the legislation or cover the same field. This observation finds support from the decision of the such and such. Minor paragraph 15, minor. In Jaberbai case, this court is in no uncertain times laid down the important things to consider is whether the legislation is in respect of the same matter, and it is on this score through effect of Article 254 has been said to effect that if the both center and the state, though competent to enact the same, the law of the center would prevail over the state. There cannot be any divergence of the views on this score having regard to the language of the Article 254. And this is irrespective of the factum that the constitutionality of the statute being always presumed in affirmative rather than in negative. It is in this context the constitutional bench of the court in decision of Karunanidhi versus Union of India stated that before any repugnancy can arise, following conditions must be satisfied. Well, these are important matters. That there is a clear and direct inconsistency between the Central Act and the State Act. Here also, my lord, that such inconsistency is absolutely inconceivable. The inconsistency between the provisions of the two acts is of such nature as to bring the two acts into direct collision with each other, and the situation is reached where it is impossible to obey the one without obeying the other. The requirement is thus clear and direct irreconcilable inconsistency between the Central and the State Act, and the inconsistency would be of such an extent that it would be otherwise impossible to obey the one without disobeying the other. 16, my lord. My lord. Then, my lord, paragraph 17, my lord. The submission of the respondent further proceeded to the effect that on a plain reading of this section, it depicts that in the event of there being any inconsistency, the special or local law will have precedence over the court. But in the event that there is no inconsistency between the two courts, will prevail. Rather, an attractive submission, but an closer scrutiny of the same plays insignificance as the aforesaid special law or local law as contained in section 41 of the Punjab Court Act was in perimeteria with the unamended section 100 matter. There was no substantial question of law at that point of time matter. So there was inconsistency. It is only after the amendment could an inconsistency be said to have developed between the two provisions, which is submitted to be saved by aforesaid section 4. Section 4 of the CPC, my lord, is, my lord, saving provision of the, my lord, civil procedure code, my lord, whereby, my lord, local laws are to be saved, my lord. My lord. Where it is true on its plain reading, the first glance of the local law seems to have been saved, but we have to examine this in light of the section Article 254 of the Constitution of India and the doctrine of repugnancy, read with section 90 of 7 of the Amendment Act, as noticed that the earlier part of the judgment incorporation of the Civil Procedure Code Amendment Act in the statute book is by virtue of conferment of power under entry 13, list 3 of the 7th schedule of the Constitution. The Constitution is the parent document and is supreme, which has binding effect on all and by virtue of the provision of the Constitution. Parliament supremacy in this regard to the adaptation of the law, if within the area of operation as provided under list 1 or list 3 is recognized. 18, my lord. Article 254 makes it unequivocal the supremacy of the parliament in the matter repugnancy of any matter falling under list 1 or list 3. There is one exception carved out, and it is important carved out in under clause 2 to a matter falling under the concurrent list. The supremacy is further reinforced by the provision of this clause 2, which records, provided that nothing in this code shall prevent parliament from enacting at any time any law with respect to the same matter, including a law adding to amending, varying or repealing the law so made by the legislature of the state. 19. Thus, even in cases falling under clause 2, where the state prevails, such law would be amended, varied or repealed by parliament by enacting law subsequently, both by virtue of clause 1 or clause 2, proviso to the clause 2, my lord. And my lord, thereafter, my lord. Paragraph 27, my lord. Now we proceed to examine section 97 of the Amendment Act and amendment of section 100 CPC by the said 1976 Act. Though this amendment right to second appeal extend further restricted only to lie where the case involves a substantial question of law. This introduction definitely is in conflict with the section 41 of the Punjab Act, which was in perimetria with unamended section 100 of CPC. Thus, so long as there was no specific provision to contrary to this code, section 4 of CPC save special or local. It comes in conflict with the conflict. Section 4 would not save. On the contrary, its language implied would make such special or local law inapplicable. We may examine now the submissions of the respondent based on the. My lord, these are the submissions, my lord. Now, my lord, paragraph 28, 29, my lord. Thus, language of section 97 of the amendment Act clearly spells out that any local law which can be termed to be inconsistent perishes, but if it is not so, the local law would continue to occupy its field. The section 29 paragraph, since section 41 of the Punjab Act expressly in conflict with the amending law, which is section 100 as amended, it would deem to have been repealed. Thus, we have no hesitation to hold that a law declared by full bench of the High Court in case of Ganpat cannot be sustained and is thus overruled. Well, ultimately, it was held that, my lord, the section 41 of the Punjab Act cannot be, my lord, cannot have supremacy over the section 100 of CPC, my lord, after the amendment after the 76 amendment, my lord. Now, my lord, second judgment, my lord. 2022 9. Two 9 SSC 593. Para 63 and 64, my lord. Here to now. May I read, my lord?
Yes.
Though it is regarding the, my lord, arbitration, my lord, though entries of entry 13, my lord, of concurrent list 3, my lord. It would thus be seen
Para 63.
63.
Hmm.
This court in such as in GC Kanungo case has observed that the subject of the arbitration finds place in entry 13 of the list of list 3. In our case, my lord, subject is found in, my lord, 63 हम लोग का कितना है 11A
13, 14.
11A 13 and, my lord,
14.
concurrent list का देखो ना Very good. Our entry, my lord, is, my lord, 11A 13 and 46, my lord. Here, my lord, entry 13, my lord. The concurrent list of the seventh schedule to the Constitution of India, it has been held that the legislation pertaining to the said entry would be made either by parliament or state legislature. It has been held that since the subject of arbitration is in concurrent list, in our case, my lord, subject is, my lord, CPC, my lord, jurisdiction of the civil court, my lord. The state can also make a law with regards to the same. The only requirement is that to validate such law, it is necessary to reserve the same for the consideration of the President of India and obtain his assent. When such assent is obtained, the provision or act so enacted would prevail in the state concert, notwithstanding its repugnancy with earlier parliamentary enactment made on the subject. It is not disputed that in the present case, the state act was reserved for consideration of President of India and assent of the President of India has been obtained. In our case, my lord, no such, my lord, reservation was made for the President of India, neither President of India has given his consent, my lord. In fact, the consent has been given by the, my lord, governor, my lord. And 64, my lord, paragraph. It will further be pertinent to note that in MPA Rural 2012, the MPA Madhyastham Adhikaran Adhiniyam 1983 state enactment provided for mandatory statutory arbitration in MP irrespective of arbitration agreement in respect of work contract in my lord, my 63 will suffice, my lord. And my lord, now the, my lord, is, my lord, the law subsection 4 of the section 50 of the Arunachal Civil Court Act is clear and unambiguous, my lord. It clearly says, my lord, appeal from the, my lord, village authority shall lie before the my lord, territorial village court council, my lord, court, my lord. So, my lord, the interpretation of the, my lord, statute, my lord, this is called golden rule of interpretation of statute, my lord. 2001 4 SSC. 2001 4 SSC. 534 para 26, my lord. उसके बाद वो एक को पड़ेगा May I read, my lord?
So see 533. 533.
Page 534, paragraph 26.
Yes.
Para 26, my lord.
Yes.
Further, we wish to clarify that it is a cardinal principle of the interpretation of the institute that the words of a institute must be understood in their natural, ordinary, or popular sense and construed according to their grammatical meaning unless such construction leads to some absurdity or unless there is something in the context or in the object of the institute to suggest to contrary matter. The golden rule is that the words of the institute must prima facie be given their ordinary meaning. It is yet another rule of the construction that when the words of the institute are clear, plain, and unambiguous, then the courts are bound to give effect to their meaning, irrespective of consequences. It is said that the words themselves best declare the intent of the law governing. The courts have adhered to the principle that the effort should be made to give meaning to each and every word used by the legislature, and it is not a sound of principle of construction to brush aside words in a institute as being inapposite surpluses if they can have a proper application in circumstances conceivable within the contemplation of the statute line. My lord, now come to my lord, section, my lord. Subsection 4 of the section 15 of the Arunachal Pradesh Civil Court Act, my lord. Page 147, my lord.
उसका definition of parliament.
One.
Section?
My lord, my lord. Earlier, before that, my lord, against the decision of the Blade Authority, my lord, under the unamended Civil Court, Arunachal Pradesh Civil Court Act, my lord, under section 15, my lord, you will find it page 143. The appeal lies, the original, my lord, Arunachal Pradesh Civil Court Act, my lord. My lord, page 143, my lord, third paragraph, my lord, provided that from the date of commencement of this act, in case an appeal is preferred against the judgment of the customary court, in the court of district judge or in the court of additional district judge, as the case may be, the court of district judge or the court of additional district judge may dispose of the same or proceed with the case de novo, my lord. This provision, my lord, has been, my lord, amended by, my lord, Arunachal Pradesh Civil Court Amendment Act 2022, my lord. And before that, my lord, in earlier, my lord, under the, my lord, the Arunachal Pradesh, Assam Frontier Regulation of Administration of Justice, my lord, an appeal lies from the Blade Authority to, my lord, the Assistant Commissioner, the Deputy Commissioner. This has been, my lord, under section 40. This has been, my lord, deleted by, my lord, by section 27 of the, my lord, Arunachal Pradesh Civil Court Act, my lord. Now there is no provision for appeal against the decision of the Blade Authority before any forum, my lord, under the AFR, my lord, 1947, my lord. So only appeal is, my lord, under the provision of the Arunachal Pradesh Civil Court Act in the Principal Act, and, my lord, has been amended again by the, my lord, Amendment Act of 2022, my lord. This will find at page 146, my lord. This is amended, my lord, by section 3 of the amendment, my lord, of section 15(3), my lord, at page 147, my lord. My lord, that day also, my lord, has gone through this provision, my lord, again, my lord. Roman 3, my lord. After the fourth proviso to the subsection 3 of section 15, following subsections shall be inserted. And the words are very clear, my lord. So this has to be interpreted in accordance with the words minor inserted in the act minor. An appeal from the village authority, if agreed to by the parties, shall lie before the inter-village territorial customary court or apex court by whatever name called, and which shall settle the case as per the local traditional customary laws under the provision of the section 40 of the Assam Frontier Administration of Justice Act 1945, my lord. As because, my lord, now, my lord, if agreed by the parties has been, my lord, deleted by an, my lord, amendment made in the, my lord, AFR under section 3, my lord. Now, my lord, it is read as a, my lord, an appeal from the village authority shall lie before the, my lord, inter-village territorial court, my lord. So it's a clear cut, my lord. We cannot, my lord, interpret in two ways, my lord. The first part is, my lord, the village authority, my lord, an appeal shall lie before the inter-village territorial customary court or apex customary court, my lord, by whatever name it is called, my lord. And the case and settle the case as per local traditional customary laws, as per, my lord, local traditional customary laws. Local traditional customary laws, my lord, may be, my lord, codified or non-codified, my lord. Customary laws are, my lord, precedents, my lord. That is either codified or, my lord, uncodified, my lord. Under the provision of section 40. Section 40 of the AFR says, my lord, the village authority will decide, my lord, any suit involving, my lord, between the, my lord, indigenous, my lord, people of the state of Arunachal Pradesh without any local limit, my lord. And section 40, my lord, when, my lord, the original KEBA, my lord, the customary court can also decide, my lord, without any pecuniary jurisdiction, my lord. Only condition is that, my lord, the parties has to be indigenous to the state of Arunachal Pradesh. That's why, my lord, no pecuniary limit has been prescribed under the first sub-rule 4 of the subsection 4 of the section 15, my lord. This proviso has been again, my lord, proviso, my lord, second part, my lord, provided that an appeal against the order of the inter-village territorial court, apex court, shall lie before the courts of civil judge senior division, the courts of civil judge senior division, the courts of additional district judge, or the courts of district judge, as the case may be, as per the territorial and pecuniary jurisdiction, my lord. Pecuniary has been inserted, my lord. Once, my lord, the inter-village territorial court decides a case, my lord, thereafter, my lord, appeal shall lie in accordance with the pecuniary, my lord, jurisdiction, my lord. The civil courts will admit those appeals, my lord. But in the appellate forum of the inter-territorial customary court, there is no pecuniary jurisdiction, my lord. Only condition is that, my lord, the parties has to be indigenous to state of Arunachal Pradesh, as required under section 40 of the AFR, my lord. So, my lord, may now put a question, my lord, whether the inter-village territorial court can, my lord, dispense justice by on, my lord, original site or not, my lord. Definitely, my lord. Because when situation arises, my lord, when a dispute between the parties are of, my lord, two different districts, two separate villages, then, my lord, this, my lord, inter-village territorial court, as a, my lord, original jurisdiction, my lord, can adjudicate, my lord.
So this provided an appeal against the order of the inter-village territorial court or apex customary court shall lie. It clearly mentioned that when apex
Here,
village territorial court or apex customary court.
Yeah.
Clearly mentioned,
shall
lie before the civil court, the
Yes,
court
my
of
lord.
civil judge.
This has to be, my lord, read in context with the, my lord, section
So
100.
that is, it makes the special law.
Yes.
This makes.
With this makes the special law, my lord. But it cannot have, my lord, supremacy over the, my lord, CPC. my lord.
Because there are no presidential assent.
Yes, my lord. Now, may I, my lord, my lord, my lord, I have given the, my lord, in my written, my lord, notes, my lord,
Hmm.
the jurisdiction, my lord, at page 3, my lord. And just I will read out, my lord, my written notes, my lord,
Mhm.
page 3, my lord.
Hmm.
Legal submissions made by the petitioner regarding the maintainability of second first appeal under the subsection section 4
Mhm.
of the section 15 of the Arunachal Pradesh Civil Code Act 2021 before civil courts. Before coming to maintainability of the second first appeal before the civil courts, it is necessary to highlight the provisions of the law regarding the adjudication of the civil dispute in the state of Arunachal Pradesh. The civil disputes adjudicate both under the provisions of the Arunachal Civil Code Act, read with CPC, and under the Assam Frontier Administration of Justice Regulation 1945, in short FR 1945, for dealing with the original jurisdiction under FR. The following provisions are essential to highlight. They are the original jurisdiction under AFR, my lord. Chapter 4 of the Chapter 4 Civil proceedings under AFR 1945 deals with the administration of civil justice after the Arunachal Pradesh Civil Code Act 2021 and Assam Frontier Administration of Justice Regulation Amendment Act 2023. Section 36, my lord, of the AFR, my lord, the provide civil justice shall be administered by the village authorities, my lord. And section 40, my lord, of AFR, the village authorities shall try all the suits without limit or value in which both parties are indigenous to the state of Arunachal Pradesh. Hence, the original jurisdiction to try all the civil suits under the AFR is the village authority. My lord, then my lord, village authority is being defined, my lord, under the AFR, my lord. The term village authority is defined under section 2F of the AFR 1945 as the village authority means of traditional village council or inter-village territorial council or apex council, my lord. The village authority includes, my lord, these, my lord, inter-village territorial councils, my lord, or court, my lord, by whatever name called, including the head Gaubura, Gauburi, head Gauburi, Gaubura, Gauburi, and traditional village head, which was inserted by AFR Amendment Act 2023. See, my lord, village authority definition under the Arunachal Pradesh Civil Code Act, my lord. The definition of village authority is also been, my lord, given under the, my lord, Civil Code Act, my lord. Section 2B, my lord. Civil courts, my lord, means civil court means a court of district judge, a court of additional district judge, a court of civil judge senior division, a court of civil judge junior division, or a customary court, including village authorities, by which whatever name called by under the Assam Frontier Regulation of Justice, my lord. A customary court including village authorities, my lord. Now, village authority includes, my lord, inter-village territorial court, my lord. Am I clear, my lord? The customary courts includes village authority. And the village authority, my lord, under section 2F includes, my lord, the inter-village territorial court, my lord. Now, my lord, classes of the courts, classes of the civil courts, my lord. Section 3 recognizes customary court as one of the 4 classes of the civil courts. Section 3, in addition to courts established under any other law for time being in force, there shall be established following classes of the civil courts. And clause E is last category is the customary court, my lord. And customary court means, my lord, village authority. Village authority means, my lord, the inter-village territorial customary court, my lord. Section 2D definition, my lord. The definition of the customary court means court of traditional council or authority of village includes indigenous to the state of Arunachal Pradesh by whatever name called includes the court of village authority under section 5 of the Assam Frontier Justice Regulation 1945. And my lord, section 5 of the AFR deals with the appointment of the village authority, my lord. And by this explanation, my lord, under the amended AFR of 2023, next page, my lord. For the purpose of section 5, village authority shall include members of traditional village council or inter-village territorial council or apex council by whatever name called as defined in such and such in clause F of the section 2, my lord. And clause F of the section 2 defines, my lord, village authority includes, my lord, inter-village territorial court, my lord. From the aforementioned definition, the customary court includes village authority under section 5, which includes the village authority by different names as defined under section 2F of the AFR 1945, namely traditional village council or inter-village territorial council or apex court by whatever name called, including head Gaubura, head Gauburi, Gaubura, traditional village head. Therefore, the civil justice is adjudicated by the civil village authorities under section 36 and 40 of the AFR 1945 in its original jurisdiction. Therefore, the inter-village customary court or the apex customary court has the original jurisdiction in the event subject matter involved disputed parties from different villages, districts, but are indigenous to the state of Arunachal Pradesh. No appeal under AFR 1945. Before the amendment of the AFR 1945, appeal from decision of the village authority lies under section 46 to assistant commissioner or deputy commissioner, who, however, section 27 of the Arunachal Pradesh Civil Court Act 2021, the section 46 has been deleted. Hence, after amendment, there is no provision for appeal against the decision of the village authority customary court under AFR 1945. Appeal under the Arunachal Pradesh Civil Court Act 2021. Under the unamended Arunachal Pradesh Civil Court Act, an appeal against the decision of the customary court village authority lies to the court of district judge, additional district judge under the provision of proviso to the subsection 3 of section 15 of the State Act. However, by an amendment called Arunachal Pradesh Civil Court Act Amendment Act 2022 by section 3 amended the subsection 3 of the section 15 by inserting subsection 4 in section 15 as an appeal from the village authority, if agreed by the parties, shall lie before the inter-village territorial customary court or apex court by whatever name called, which shall settle the case as per the local traditional customary laws under the provision of the section 40 of the Assam Frontier Administration of Justice Regulation 1945. Hence, under the aforesaid provision, the inter-village territorial customary court has the appellate jurisdiction to decide the appeal on two terms. Firstly, if the decision is rendered by a village authority, excluding the inter-village territorial customary court or apex customary court. Secondly, if the parties are indigenous to the state of Arunachal Pradesh and further vested without any pecuniary jurisdiction. Provided that an appeal against the order of the inter-village territorial court or apex court, customary court, shall lie before the courts of civil judge, senior division, the court of civil judge, senior division, the courts of additional district judge or courts of district judge as the case may be as per the territorial and pecuniary jurisdiction. However, by amendment made by section 13 in the Arunachal Pradesh Administration of Justice Amendment Act 2023, the word in subsection 4 of the section 50, if agreed to by parties, the word if agreed by the parties or agreed by the parties to appeal has been substituted. From the above mentioned provisions of the subsection 4 to section 15 of the Civil Court Act 2021 makes it abundantly clear that the appeal from the village authority lie before inter-village territorial customary court or apex customary court. Here the customary court includes, which connotes and includes the council council and if the parties are indigenous to the state of the Arunachal Pradesh as required under section 40 of the AFR, irrespective of
Okay.
pecuniary value, and the instant case.
So, yeah. We'll continue at two.
Minor.
Just a minute, huh? Yeah, let me pause also. So, it'll take more time.
Just I will read out only some
Uh-huh.
paragraph, two paragraphs.
Okay, today what we'll do, your part will hear. And then, the other side, let us see, okay,
Minor.
let's up to two, because.
I'm just going to pause there. Yeah, please, madam. I will only read out few paragraphs from my list of date, madam.
Okay.
Page 6, madam, last
Hmm.
paragraph, madam. Page 6, madam.
Yes,
May I read, madam?
yes.
From the above mentioned provisions of the subsection 4 of the section 15 of the Civil Code Act 2021 makes it abundantly clear that the appeal from the village authority lie before the inter-village territorial customary court or apex customary court. Here, the customary court includes with connotes and includes the council and if the parties are indigenous to the state of Arunachal Pradesh as required under section 40 of the AFR, irrespective of the pecuniary value, and the instant case both the parties have admittedly filed appeal under the provision of the section 15(4) of the Civil Code Act 2021 before the Inter-Village Territorial Customary Court at Basar against the Keva decision dated 16/7/2025 and against the decision dated 21/2/2026 of the First Appellate Court again filed second first appeal under the section 15(4) of the of the civil judge senior before it should be before civil judge senior division, which barred by section 100 and 101 of the CPC as second appeals from the degrees of the first appellate court lies to this honorable court, this honorable high court, that too only on the ground of substantial question of law. The provision to subsection 4 of the section 15 shall be applicable if the inter-village territorial customary court exercises its jurisdiction or exercise its original jurisdiction and renders decision on original side, then the first appeal shall lie to the civil courts according to the pecuniary jurisdiction. In the instant case, in the two appeals against the decision of the village authority, and both the parties have consciously exercised appeal under section 15(4) of the Civil Code Act. Now, after the decision of the appellate court, there cannot be first appeal before the civil court, as embargo has been provided under section 100 of the CPC. Section 100 of the CPC, I have quoted, madam, may skip, which gives exclusive jurisdiction to the High Court for entertaining second appeal from degrees of the first appeal court. There cannot be two interpretations as regards to the provisions for filing second appeal against the decision of the appellate court. Again, in the civil courts, in that event, the provisions of the section 100 will become redundant, and the same shall amount to the repugnancy of the law enacted by Parliament and the state legislature, and the amounts to deem repealing of section 100 of the CPC by proviso to subsection 4 of section 15 of the Arunachal Pradesh Civil Code Act. It is to note here that the CPC CPC and its 76th amendment was applicable in the spirit in the state of Arunachal Pradesh. However, it is adopted and made applicable in the state of Arunachal Pradesh by an act of state legislature called Arunachal Pradesh Civil Code Act 2021, having the assent of the governor of the state and proviso to the subsection 4 of the section 15 was made applicable only in the year 2022 by an amendment, and the intention of the legislature was never deemed to repealing of the section 100 of the CPC in view of the article 254(1) and to surplus 2 of the Constitution of India, though the state legislature has the power to legislate the Civil Code Act as the same force under the entry 1113 of the list 3 concurrent list under the 7 schedules of the Constitution of India. Under the concurrent list, both the Parliament and the state legislature has power to act on the present subject matter. However, Arunachal Pradesh Civil Code Act cannot have supremacy of the CPC or be inconsistent with the parliamentary legislation, namely the section 100 of the CPC. And therefore, my lord, the proceeding before the my lord, senior division may be my lord, first my lord. This is my lord submission, my lord.
Okay.
Correct, no?
Yes.
My place loss. Lordship, regarding the supremacy of state legislature and the parliament, I think, Lordship, my senior submitted their power to enact the law by the state legislature and the parliament, and that is no doubt, Lordship. Lordship, here the question is, the filing of appeal against the order passed by the Interblessed Territorial Customary Court. Instead of filing appeal under section 15(4), it has to be filed under section 100 of CPC. Now, the petition before your lordship under 2 to 7 is now the petitioner is challenging the jurisdiction of Learned Civil Judge Senior Division, where the appeal has been filed under section 15(4) of Arunachal Pradesh Civil Court Act. My lordship, to take you to the provisions once again, of course, my lordship has gone through on many occasions in this case also. So lordship, may I take you to my affidavit in opposition? Page number, lordship. 326, lordship. Section 15(4).
Yes.
May I read once again, lordship? After the fourth provision to subsection 3 of section 15, the following subsection shall be inserted. 4. An appeal from Blaze Authority, if agreed by the parties, lordship, this agreed word has been deleted and the agreed by the parties has been inserted, shall lie before the Interblessed Territorial Customary Court or Apex Customary Court by whatever name called. Now this clause 4, it is very clear that, lordship, the appeal against the order of Blaze Authority shall lie before the Interblessed Territorial Customary Court. Now the next, lordship, provision, provided that an appeal against the order of Interblessed Territorial Court or Apex Customary Court shall lie before the Court of Civil Judge Junior Division and the Court of Civil Judge Senior Division, the Court of Additional District Judge or the Court of District Judge, as the case may be, as per their territorial and pecuniary jurisdiction. Subject to the territorial, pecuniary, and then lordship, territorial jurisdiction, the appeal against the order of Interblessed Territorial Customary Court shall be before the Civil Judge, Senior Division, Junior Division, Additional District Judge, and then District Judge, lordship. Now, lordship, here the question of filing appeal under section 100 against the order passed by the Interblessed Territorial Customary, how does it come, lordship? As lordship aware that there is a 2 provisions for adjudication of the civil dispute, civil suit in our state of Arunachal Pradesh. The one is by filing a title suit, civil suit under CPC, provisions of CPC. Then it has to be under section 9, then section 96, first appeal, then aggrieved by the first appeal, then section 100, subject to the, when there is a substantial question of law, that will be applicable under section 100 before the High Court, lordship. Now here the provisions, Lordship, Arunachal Pradesh Civil Code Act, which clearly provides that, Lordship, appeal against the order of Blaze Authority, it shall lie before the Interblaze Territorial Customary Court. Then again, Interblaze Territorial Customary Court, it has to be before the Civil Court, Lordship. Now, Lordship, by reading the provision, that is the definition of, Lordship, Blaze Authority, that is provided under AFR, Assam Frontier Administration of Justice Regulation Amendment Act 23, phase 3 to 7, Lordship. 3 to 7.
Yes.
Here, Lordship, clause F, amendment of section 2 and clause F, Lordship, just above the clause number 4, Lordship,
Mhm.
327, page number. The definition, Blaze Authority.
It's 3 to,
Lordship, page number 327
yes,
of my affidavit in opposition.
okay, yes.
The definition of Blaze Authority.
Mm.
Blaze Authority means members, Lordship, of traditional Blaze Council or Interblaze Territorial Council or FX Council by whatever name called, including head Gaubura, head Gauburi, Gaubura, Gauburi, and traditional Blaze head. Here the definition provides that, Lordship, the who shall preside over the Blaze Authority, the means customary court, Lordship. Since customary court and Interblaze Territorial Customary Court, both are the customary court, therefore they will be presided over by the Gaubura, Gauburis, head Gaubura, Gauburis, appointed under section 5 of AFR, Lordship. But this definition does not say that, Lordship, the Interblaze Territorial Customary Court will also have the original jurisdiction. Regarding the jurisdiction of Interblaze Territorial Customary Court, whether it will be appellate court or it will be original court, that has been already decided by the ordinate bench of this honorable court, Your Honor, in Jumia and others versus Jumi and others in CRF number 43 of 2023 laws. Second page, Lordship. I start from second page, Lordship, FERA number 3. FERA number 3, Lordship.
Hmm.
The short question. The short question arising in the present proceeding as to whether the Interblaze Territorial Customary Court, which had decided the issue, would have an original jurisdiction in the matter and or can only have the affiliate jurisdiction after the issue was so decided by the jurisdictional Blaze Authority. Now, skip this next para, this is the submission. Then last para, Lordship. Here the provisions has been quoted again, Lordship. The subsection 4 of section 15 of said Arunachal Pradesh Civil Code Act 21 is brought into existence by the Arunachal Pradesh Civil Codes Amendment Act 22 is extracted here in below. After the fourth provision to subsection 3 of section 15, the following subsection shall be inserted. An appeal from the Blaze Authority, if agreed to by the parties, shall lie before the Interblaze Territorial Customary Court or Apex Customary Court by whatever name called, who shall settle the case as per the local territorial customary laws under the provisions of Section 40 of Assam Frontier Administration of Justice Regulation 1945. Provided that an appeal against the order of the Interblaze Territorial Court or Apex Customary Court shall lie before the Court of Civil Judge, Junior Division, the Court of Civil Judge, Senior Division, the Courts of Additional District Judge, or the Courts of District Judge, as the case may be, as per their territorial and pecuniary jurisdiction. Provided further that, my lordship, this para may be skipped. Now down below laws. A ferrugel of subsection 4 of the section 15 of Arunachal Pradesh Civil Courts Act 21, as amended, would reveal that the Interblaze Territorial Customary Court or the Apex Customary Court, by whatever name called, shall have the affiliate jurisdiction over the decision of a blaze authority. Lords, provided that the parties agree to submit to such appellate jurisdiction. The said provision of subsection 4 of section 15 of Arunachal Pradesh Civil Court Act, as amended, would also go to reveal that the Interblaze Territorial Customary Court in an issue as arising in the present proceedings would not have an original jurisdiction. Now, this issue has been, lordship, has already been decided in this civil revision petition. Now, it is crystal clear, in fact, in the Act also, lordship, under Section 4 Amendment Act also, it is very clear that the appeal against the blaze authority shall be filed before the Interblaze Territorial Customary Court, and then again thereafter it will be before the civil court, subject to the territorial and pecuniary jurisdiction. Now, lordship, here the question is how one can be allowed to avail two parallel provisions of law for the same matter at the same time, lordship. Now, lordship, when the statute provides for a certain things to be done in a particular manner, lordship, I'd like to rely on the one judgment, 2014-3 SSC 502. 2014. 14. 4 in it. Huh. Para 61, lordship, my lordship will find it, phase 538, lordship, 538. Para 61. May I read para 61?
Yes.
It is well settled that where the statutory statutes provides for things to be done in a particular manner, then it has to be done in that manner and in no other manner. These propositions of law laid down in Taylor versus Taylor was first adopted by the Judicial Committee in Nazir Ahmad versus King of Emperor, and then followed by the bench of 3 judges of this court in Rao Singh Bahadur Singh versus State of Bindia Pradesh. This proposition was further explained in Para 8 of the State of UP versus Singhara Singh by a bench of 3 judges in the following words. The rule adopted in Taylor versus Taylor, it is well recognized and it is founded on sound principle. Its result is that if a statutory has conferred a power to do an act and has laid down the method in which that power has to be exercised, it necessarily prohibits the doing of the act in any other manner than that which has been prescribed. The principles behind the rule is that if this were not so, the statutory provisions might as well not been enacted. Now, lordship, it also talks about the intention of the legislature, lordship. The legislature also aware that, lordship, there is a CPC, the provisions of CPC. But despite of that, lordship, They are aware that since there is a unique practice in the state of Arunachal Pradesh for amicable resolution of suits, any disputes, that is by the Blaze Authority, Lordship. Earlier, there was a Assam Frontier Regulation wherein under Section 5, the GB Blaze Authority was appointed by the Deputy Commissioner. Now also, Lordship, but before an amendment, the affiliate provision was provided before the Deputy Commissioner and ADC. So therefore, in order to avoid all these difficulties, hindrances, now Civil Court Act was amended, Lordship, and the Act is very clear, Lordship, where to go, what steps to be followed. And moreover, the provisions of CPC does not envisage the power of the Blaze Authority, Lordship. Now, next, Lordship, I'd like to rely on the interpretation of status, how the status has to be interpreted. First and foremost things has to be given its grammatical meaning, literal meaning, Lordship. If there is any ambiguity, then of course, Lordship, the rest of the provisions of interpretation will be applicable. But when there is the provisions of Act is very clear, it has to given its in literal meaning, Lordship. 2007 to SCC, Lordship. 230. Para 40, Lordship. My Lordship will find at page number 243. Para 40, page 243. 243.
Yes.
Para 40, Lordship.
Hmm.
It may be mentioned in this connection that the first and the foremost principles of interpretation of statute is various systems of interpretation is the literate rule of interpretation. The other rule of interpretation, example, the mischief rules, purposive interpretation, etc. can only be resorted to when the plain words of a statute are ambiguous or lead to no intelligible results, or if read literally would nullify the very object of the statute. Where the words of a statute are absolutely clear and unambiguous, recourse cannot be had to be the principles of interpretation other than the literal rule. White Swedish Match AB versus Securities and Exchange Board of India, as held in Prakash Nath Khanna versus CIT. The language employed in a statute is the determinative factor of the legislative intent. The legislature is presumed to have made no mistake. The presumption is that it intended to say what it has said. Assuming there is a defect or an omission in the words used by the legislature, the court cannot correct or make up the deficiency, especially when a literate reading thereof produces an intelligible result. By Delhi Financial Corporation versus Rajiv Anand, where the legislative intent is clear from the language, the court should give effect to it. By Government of FE versus Road Loaders Owners Welfare Association, and the court should not seek to amend the law in curve of interpretation, Lordship. Now, Lordship, next para, 41. As stated by the Justice Frankfurter of the US Supreme Court, so and so, even within their area of choice, the courts are not at large. They are confined by the nature and scope of judicial function in its particular exercise in the field of interpretation. They are under the constraint imposed by the judicial function in our democratic society. As a matter of verbal recognition, certainly no one will gainsay that the functions in construing a statute is to ascertain the meaning of the words used by the legislature. To go beyond it is to usurp a power which our democracy has lost in the elected legislature. The great judges have constantly admonished their brethren of the need for discipline in observing the limitations. A judge must not rewrite a statute, neither to enlarge nor to contract it. Whatever temptations the statesmanship of policy making might wisely suggest, construction must issue interpretation and evisceration. He must not read by way of creation. He must not read out except to avoid patent nonsense or internal contradictions. Para 42. As observed by the Lord in word in so and so, to adhere as close as possible to the literal meaning of the words used is a cardinal rule from which, if we depart, we launch into a sea of difficulties which it is not easy to fathom. 43. In other words, once we depart from the literal rule, then any number of interpretation can be put to a statutory provisions. Each judge have a free play to put his own interpretation as he likes. This would be destructive of judicial discipline and also the basic principle in a democracy that it is not for the judge to legislate, as that is the task of the elected representatives of the people. Even if the literal interpretation results in hardship of inconvenience, it has to be followed. Hence, departure from the literal rule should only be done in very rare cases, and ordinarily there should be judicial restraint in this connection. Now, Lordship, para 44, very small para, Lordship. May I read the para only, relevant para.
Yeah.
Again and again, this board has insisted that in construing enacted words, we are not concerned with the policy involved or with the result, injurious or otherwise, which may follow from giving effect to the language used. Now 45, Lordship. Hardship or inconvenience cannot alter the meaning of the language employed by the legislature if such meaning is clear on the face of the statute. Lordship. 46. The rule of interpretation other than the literal rule would come into play only if there is any doubt with regard to the express language used, or if the plain meaning would lead to an absurdity where the words are unequivocal. There is no scope for importing the rule of interpretation so and so. It is 47. It is only where the provisions of a statute are ambiguous that the court can defer from a literal or a strict construction. Where the word of a statute are plain and unambiguous, effect must be given to them, Lordship. And on the same interpretation, Lordship, I would like to rely 2001 as my senior counsel of the day rely. That Lordship, para 26 that my senior has already relied. So Lordship, I'm just providing the citation 2001 for SCC 534.
Yes.
Page 534, Lordship. And relevant para 26, 552, 552, Lordship.
Yes. First.
Married, Lordship.
You read it.
Yes. Further, we wish to clarify that it is a cardinal principle of interpretation of a statute that the word of a statute must be understood in their natural, ordinary, or popular sense and construed according to their grammatical meaning, unless such construction lead to some absurdity or unless there is something in the context or in the object of the statute to suggest to the contrary. The golden rule is that the word of a statute must prima facie be given their ordinary meaning. It is yet another rule of construction that when the word of a statute are clear, plain, and unambiguous, then the court are bound to give effect to that meaning, irrespective of the consequences. Now, Lordship, as I've read over the section 15.4, the language given in section 15.4 is, Lordship, very clear, Lordship. The provided how appeal should be, the stages of appeal. And regarding the, Lordship, the jurisdiction of interblessed territorial customary court, by reading that, Lordship, definition, which has been already clarified by the coordinate bench, Lordship, saying that interblessed territorial customary court is a affiliate court only. Right. Okay. Now, Lordship, my next point of argument would be, when the statutory provides the remedy, Lordship, the one has to exhaust all those remedies, Lordship. A litigant cannot bypass the mandatory statutory appeal, Lordship. After filing appeal before the Interblessed Territorial Customary Court under Arunachal Pradesh Civil Court Act, Amendment Act 2022, how I can jump under appeal by filing a section 100 appeal before the Honorable High Court, Lordship? Because the remedy has been provided, saying that from the order of Blessed Authority, you have to file appeal before the Interblessed Territorial Customary Court. Thereafter, I have to file appeal before the Civil Court. So, Lordship, I have to exhaust all those statutory remedies. So, regarding this, Lordship, I would like to rely on one judgment. Small para, Lordship. (2022) Supreme SC 1053, State of Madhya Pradesh and another versus Commercial Engineering and Bodybuilding Company Limited, Lordship. My Lordship will get the relevant FERA 6, page number 3, Lordship. FERA 6, page number 3, Lordship. May I read, Lordship? At this stage, a recent decision of this court in case of the state of Maharashtra and others versus Great Shift India Limited, civil appeal so and so, is required to be referred to after taking into consideration the earlier decision of this court in case of United Bank of India versus Satyawati Tondon and others, reported in 2010 so and so. It is observed that and held that in a tax matter when a statutory remedy of appeal is available. Now here it's referring the tax matter, Lordship, where the act itself provide the appeal remedy. It has to be exhausted first. Remedy of appeal is available. The High Court ought not to have entertained the writ petition under Article 2 to 6 of the Constitution of India against the assessment order by passing the statutory remedy of appeal. While holding so, this court considered the observations made by this court in para 49 to Satyawati Tondon, which read it under. Now, Lordship, here the below paragraph also provides. Now, Lordship, may I take you to next page, Lordship? Next page. First, small,
Just a minute.
Next page only, Lordship, page 4. Here is small para 6, Lordship, provided. This para is the continuation of previous page, Lordship.
Yes.
So may I read, Lordship?
Hmm.
The act has been enacted with a view to provide a special procedure for recovery of debt due to the bank and the financial institution. There is a hierarchy of appeal provided in the act, namely filing of an appeal under section 20. And these fast track procedures cannot be allowed to be dwelled either by taking recourse to proceeding under section 226 and 227 of the Constitution, or by filing a civil suit, which is expressly barred, even though a provisions under an act cannot expressly ousted the jurisdiction of court under Article 226 and 227 of the Constitution. Nevertheless, when there is an alternative remedy available, judicial procedure demands that the court refrain from exercising its jurisdiction under the said constitutional provisions. This was a case where the High Court should not have entertained the petition under Article 227 of the Constitution and should have directed the respondent to take recourse to the appeal mechanism provided by the Act. Now, it also says, Lordship, even under Article 226 and 227, when there is a remedy available, Lordship, now, Lordship, let's coming back to the application before your Lordship. May I take you to the civil revision petition? Fair Lordship. What is the application before this honorable court and the prayer, Lordship? Now, before coming to this fair position, Lordship, now, Lordship, when there is a dispute between the state legislature and the parliament, of course, the supremacy has to be decided as my senior has submitted. If the assent has been given by the president, that it has a supremacy. But that such cases will apply when there is a case of repugnancy, Lordship. There is a contradiction, dispute between two acts, Lordship. So my respectful submission is, Lordship, here the competency of state legislature is not under challenge, Lordship. And in fact, they have the power to enact the Arunachal Pradesh Civil Code Act, Lordship. There is no dispute, Lordship. If the petitioner says, Lordship, there is a contradictory between the Arunachal Pradesh Civil Code Act and the CPC, what they ought to have do, Lordship? They ought to have challenged the Arunachal Pradesh Civil Code Act by filing a appropriate application, Lordship. Now the petition before your Lordship, Lordship, may I take you to the prayer portion, Lordship? What is their prayer? What is this is the application under 227, Lordship. And my Lordship is aware, when there is a jurisdiction of fundamentals, jurisdiction error is apparent, evident, then only under 227 application is maintainable, Lordship. Page 48, it's a prayer portion, page 48.
Yes.
Also. May I read, Lordship?
Yes.
In the premises aforesaid, your Lordship may be pleased to admit this petition, call for the records, and issue rule upon the respondent to show cause as to why the impugn order dated 13/3/26 passed in civil appeal number so and so, and in misapplication number so and so, wherein the learned civil judge, senior division, West Siang district, Arunachal Pradesh, without jurisdiction, Lordship, and most erroneously admitted the appeal number so and so in civil appeal number so and so. In the interim, the operation of the cover decision dated 21/2 passed by the appellate Interblaste Territorial Kaba Basar was suspended or stayed until the next date of the hearing and to be set aside and quashed. And upon cause shown in hearing the parties and perusal of the records, your lordship may please to make the rule absolute and pass such further or other orders as your lordship may deem fit and proper. In interim, pending disposal of this rule, your lordship would be graciously pleased to stay the further proceeding of appeal so and so, so and so. Basically, lordship, under this application, what they are challenging, the petitioner is challenging is the jurisdiction of the civil judge senior division who admitted the appeal filed by the respondent against the Kaba decision passed by the appellate court. Now, lordship, where is the question that the civil judge senior division has acted beyond the jurisdiction, lordship? Section 15(4) of Arunachal Pradesh Civil Courts Act, lordship, Amendment Act 2022, clearly provides the jurisdiction of civil judge senior division who shall entertain appeal against the order passed by the Interblaste Territorial Customary Court. Therefore, lordship, the present civil revision petition is not maintainable. If in case, lordship, regarding the power of second appeal, if the petitioner want to invoke under section 100, that has to challenge the act itself, lordship. But as far the act under section 15(4), the civil appeal filed against the order of Blaze Authority, who acted as the affiliate authority, that has been admitted by the Civil Judge Senior Division as per Section 15(4) of Arunachal Pradesh Civil Court Act.
Okay.
That's all, lordship. Deeply obvious.
My lord, just to clarify one thing, my lord. Challenging my lord, section, my lord, the subsection, my lord, 4 of section 15 does not arise, my lord. Because intention of the legislature is, my lord, not otherwise like that, my lord. It's a clear cut, my lord. The words are clear in the Civil Court Act also, my lord, that appeals shall lie from Keba to the Interblaste Territorial Court, my lord. It's clear cut, my lord. So question of challenging the act doesn't arise, my lord. Even if it's so, my lord, it's a deemed repeal, my lord. And my lord, the judgment which has been placed before your lordship by my learned friend in my lord TRP number 43 of 2023, Jumia Ram versus Jumiri Ram, it's a not authoritative judgment, my lord. The facts are quite different, my lord. My lord, kindly take up this judgment, order, my lord, judgment, my lord, for a moment, my lord. Here, my lord, the matter has been, the challenge was, my lord, that, my lord, a Keba order passed by, my lord, Interblaste Territorial Customary Court, my lord. Wherein, my lord, my lord, the disputed land in question is at, my lord, Sago Blade, and the parties are also from the Sago Blade, my lord. And it was rendered, my lord, prior to the, my lord, amendment of the AFR 2023, my lord. May I read, my lord? The challenge in the present proceeding is to decision dated 23/7/2023 taken by Interblaste Territorial Customary Court deciding a dispute pertaining to a plot of land between the petitioner and respondent herein situated at Sago Blade, my lord. The parties are also from Sago Blade, and my lord, the disputed land is also at Sago village, my lord. So it could have been decided by the, my lord, village authority, Keva, my lord, not by a, my lord, inter-village territorial customary court, my lord. The short question arises in the present proceeding is as to whether the inter-village territorial customary court which had decided the issue, the decision was rendered by, my lord, inter-village territorial customary court, which had decided the issue would have an original jurisdiction in the matter or can only have an appellate jurisdiction after the issue was so decided by jurisdictional village authority. Jurisdictional village authority would be the minor, the Kava minor, not the inter-village territorial court minor. Mr. Parmen earned counsel for the petitioner by placing reliance on the provisions of the Arunachal Pradesh Civil Code Act 2021 as amended in 2022, has submitted the inter-village territorial customary court or the apex court by whatever name called has been now denoted as a appellate forum against the decision of the village authority provided it is agreed to by a particular. This was also amended, my lord, by a subsequent amendment in AFR 2023, my lord. Subsection 4 of section 15 of the State Arunachal Pradesh Civil Code Act has brought into existence of Arunachal Pradesh Civil Code Act in extracted below. This has been, my lord, Thereafter, my lord, a perusal of subsection 4 of section 15 of the Arunachal Pradesh Civil Code Act as amended would reveal that inter-village territorial customary court or the apex customary court by whatever name code shall have the appellate jurisdiction over the decision of the village authority provided the parties agrees to the submit such appellate jurisdiction, my lord. Now this provided the parties agreed to the submit to the appellate jurisdiction has been, my lord, deleted, my lord. Now it's a mandatory provision, my lord. Second, next, my lord, the said provision of subsection 4 of the section 15 of the Arunachal Pradesh Civil Code Act 2021 as amended would also go to reveal that inter-village territorial customary court in an issue as arising in the present proceeding, my lord, in that context, my lord, would not have an original jurisdiction. And the inter-village territorial court, my lord, in the situation, my lord, where in this present case, my lord, the parties are from the Sago village and disputed land, my lord, is in the, my lord, Sago village, my lord. So question of, my lord, territorial customary court does not arise as a original jurisdiction, my lord. It has to be decided by, my lord, Keva, my lord, a village authority under section 5, my lord, whatever the name is called, my lord. The parties to the present proceeding are at agreement that the land which is in dispute falls within the jurisdiction of Sago village and also to the extent that jurisdictional village authority had not considered the issue and pronounced this judgment thereof. Here, my lord, instead of, my lord, decision to be being rendered by a Keva, my lord, village authority, the decision was rendered by the, my lord, the inter-village territorial customary court, my lord. That's why, my lord, in this context, my lord, it was held that, my lord, the inter-village territorial council, my lord, inter-village territorial village customary court doesn't have that original jurisdiction, my lord. This cannot be relied upon, my lord. And now, my lord, just for the sake of repetition, my lord, the civil justice, my lord, under AFR is to be, my lord, rendered by the village authorities, my lord, under section 36, my lord. It's clear, my lord, unambiguous, my lord. And it should be read with, my lord, harmoniously read with, my lord, section 40, my lord, of the AFR. The village authority shall try all the suits without limit or value in which both parties are indigenous to the state of Arunachal Pradesh, my lord. And the village authorities has been defined, my lord, both under the, my lord, AFR and the Arunachal Pradesh Civil Court Act, which includes, my lord, the inter-village territorial customary court, my lord. That's why, my lord, the inter-village territorial council court has both the original as well as the appellate jurisdiction, my lord. When there are dispute between the two parties, my lord, of different districts of different villages, then definitely, my lord, inter-village territorial court will, my lord, decide as original jurisdiction, my lord. Under section 5, my lord, village authorities are appointed for a particular village, my lord, to, my lord, redress the, my lord, the grievances, my lord, and try the suits, my lord, in accordance with the customary law, my lord. This is my submission,
Okay.
outline, my lord.
So what we'll do, if there is any clarification,
My lord.
we'll place once,
My
but
lord.
then for the time being, I'll keep it as a reserve.
My lord.
Add Mr. Arsakia, Learned Counsel for the petitioner. So Arsakia, Learned Senior Counsel, assisted by Mr. Aibam, Learned Counsel for the petitioner. Also had Mr. Lawlin, Learned Counsel for the respondent, staff. Hearing concluded, judgment reserved. That's good.
Deeply obliged.
को स्टेपलर करवा इसको और ये जो इसको प्रिंट हाँ जरूर ये बुक्स ले लो हाँ
Matter number 9.
May I be lordship, my lord? Now, this
Yes.
is an anticipatory bill application, my lord. Your interim, my lord, this case that he was called for, my lord. And we've appeared before the IO, my lord, as per the direction, earlier direction in the order detail, my lord. The FIR is at page 23, my lord.
Yes, my lord, their statement has been recorded.
Okay.
And my lord, here the IO has stated that they were not arrested because they had complied with the notice, my lord.
My lord, we complied.
They
That's
have
not
complied with the
required.
notice, my lord. Initially, the notice was issued to them under section 35(3) of BNSS, my lord. So in compliance of the notice, they appear, their statement has been recorded and they are cooperating with the investigation.
Not required to arrest.
Yes, my lord.
So then this
Then, my lord, in that case, my lord, if they are cooperating with the investigation, then in that case, my lord, the apprehension will remain there, my lord, no doubt, because although they have complied with the notice, an interim has also been granted by this honorable court. So now at this scenario, my lord, at this present situation, my lord, if they are cooperating with the investigation, let the earlier interim bail granted to them may be made absolute, my lord,
okay.
with the same terms and condition, my lord.
Okay.
We'll keep on cooperating, my lord.
I had Mr. B.K. Mahajan,
My lord.
Land Counsel for the petitioner staff. Also had Mr. Epe, Land Additional PP for the state staff. Para. By an order dated 29/4/2026.
Mm.
The petitioner was just a minute.
Two petitioners, my lord.
Two petitioner.
Yes, my lord.
Husband and wife, my lord.
Husband and wife, my lord.
Okay.
Mm.
Both the petitioners, namely, Pranjal Pathak and Ritiparna Totoki, alias Ritiparna Kataki, were granted interim anticipatory bail. Directing for their release on execution of a bail bond of rupees 50,000 each, with one surety of like amount, to the satisfaction of the arresting authority with certain conditions. Staff, Mr. Ete, Learned Additional PP, Para, on record, submits that since the accused, since in compliance with the earlier notice issued against the accused under section, notice under which section?
35 subsection 3.
35(3), my lord.
35 subsection 3,
Dated, my lord, 12/4/26.
BNSS, on dated 12/4/2026. 2026. Appeared before the police, appeared before the police.
On second five, two
Oh,
five,
appeared before the police on
2/5/2026.
2/5/2026. And on their such appearance, their statement have been recorded, comma. They were not arrested. Arrested, huh? Okay. And as they were cooperating with the investigation of the case, they were not arrested.
Yes, ma'am.
Stop, huh? We further submit that the accused applicant is cooperating with the investigation and therefore he has no objection if the interim anticipatory bail granted to the accused persons are made absolute with the same terms and condition. Stop, huh? Peruse the record, stop, huh? It appears that the accused, after obtaining the interim anticipatory bail, is cooperating with the investigation of the case. And in view of the above, their custodial interrogation may not be required at this
Yes, ma'am.
at the moment.
Yes, ma'am.
Therefore, and stop, huh? Considering the submission and the records produced before the court, the interim it is provided that the interim anticipatory bail granted to the accused on 29/4/2026 is now hereby made absolute
Yes, ma'am.
with the same terms and condition. What are these?
My lord, cooperate with the investigation, my lord.
Will appear
Okay.
again.
To appear before the IO as and when required, my lord.
Yes, yes, ma'am.
Yes, okay. On the subject to the following terms and condition, we'll
Yeah.
repeat it.
Yes,
Okay.
ma'am. Yes, ma'am.
Well,
That the accused shall appear before the accused shall cooperate and appear before the IO of the case as and when called for. 2, that the accused applicants shall not directly or indirectly make any inducement, threat, or promise to any persons acquainted with the fact of the case so as to dissuade him from disclosing such facts either to the police officer or to the court. Next. That the accused applicants shall not hamper or tamper with the evidence and the witnesses of the case in any manner. Stop. Next. That the accused applicant shall not leave the jurisdiction of the. See, this is confined to New Delhi police station.
Yes, madam.
And
Yes,
we
ma'am.
can say that state.
Yes, my lord.
This jurisdiction can be extended to state.
Yes, my lord.
They shall not leave the state of Arunachal Pradesh without prior information to the eye of the case. Okay,
Well,
till,
Till the completion of the investigation.
till the completion of investigation. Stop. Para with the above, this, this bail application stands disposed of.
Yes,
Okay.
madam. CD may be returned, madam. CD is with.
Return the CD.
Yes, madam.
Okay.
Obliged.
highly obliged, ma'am. Obliged, ma'am.
Matter number 11,
Yes, my lord has directed to the take steps upon the respondent of counsel for the respondent. I have also taken steps upon the counsel for the respondent, my lord. And I have filed additional affidavit, my lord. But this case,
Earlier appeared for the respondent,
none appeared.
then
I
none
have also
appeared.
taken custody service, my lord.
Okay.
And again, this step through the council, my lord. So this
So
is very-
additional affidavit means,
additional all service upon the council. for
okay,
the-
compliance affidavit.
Yes, yes. This is a simple case, my lord. On
They
the
have
basis
they
of-
received, have they received?
Yes, my lord. I have filed affidavit, my lord. This is a Very simple case, my lord.
What-
On the basis of written statement, my plaint was rejected, my lord. Now, the subtle law is that no, on the basis of written statement, no, it is on the basis of plaint, suit can be rejected, my lord. On the basis of written statement, my suit was rejected, my lord. May I, my lord?
Just a minute. Sir.
I'm only praying for my lord to return the matter to before the trial court, my lord.
No one appears. Where is the compliance affidavit?
My lord, that is in my affidavit. my lord.
Okay, so we'll record that despite they have not appeared.
If the matter can be remanded back to the trial court, my lord, that would be fine too.
Hmm?
If the matter may be remanded back, my lord. Or this judgment has been passed in complete violation of the subtle principle of law. my lord. On the basis of written statement, my suit has been rejected, my lord.
What we'll do is we'll place it or get it listed under admission,
My lord.
on which date we'll dispose of.
Yes, my lord. Next week, my lord.
Hmm. Mr. B. Picha, Learning Counsel for the appellant. This is appeal,
Yes.
appellant, okay, staff, huh? No, none appears for the respondent on call, although the service upon. How many respondents are there?
One, my lord.
Service upon him or her was posed to dusty mode, dusty mode, huh? A service upon the respondent has been effected through dusty mode, okay, stop. So, no. Since the service is complete, okay. Has it been recorded that it is complete?
Yes, my lord.
Okay, in view of the above, the service upon the respondent is treated to be complete, huh?
My lord, yes.
Staff, huh? Okay, list this matter. When?
Yes, my lord. On, my lord, this
For admission, huh?
can it be on, my lord,
After 2 weeks,
29, my lord.
29,
Yes, my lord, because I have the.
This 29?
Long back, man. Yes, 29 May, man.
29 last date? No, 29 last, it would be difficult.
Yes, yes.
29. 29, because
28,
in the afternoon at
Yeah.
2, there will be a consumer commission.
My lord, yeah.
28,
26,
list it
my-
down.
28 would be the division bench, my lord.
okay.
Can it be on 20? Sorry, man. After a
So
week,
who appeared before the trial court in respect,
Counsel
for
Ado,
respondent?
my lord.
Hmm?
One council name Ado, my lord.
Which district?
West Siang, Alok.
Okay, when?
My lord,
After a week or 2?
I'll suggest the date, my lord.
Okay,
4, my lord, 4 June.
4 June for admission. Oh,
Okay.
Matter number 12,
Yes.
May I please submit mine?
Hmm.
My lord, may kindly see the office note. We have taken the fresh step long time back through the concerned police station. And it has been, I think, service has been completed, but still no one is representing the informant. This is a civil revision petition
Hmm.
challenging the order of the Session Court UP, where the charges were framed under 306 and 34. Abatement of suicide case.
Hmm.
The petitioner was the alleged girlfriend. So, my lord, today, may I request if the respondent number 2 is not willing to pursue this method, then any amicus curiae maybe
So respondent number 2 is
informant, the father of the
Okay,
This is-
informant, we can appoint one legal aid.
Lordship, because
Okay.
at last occasion, Lordship, the Honorable Court has observed that if the next time, next hearing, if no one appeared, then amicus will be appointed. So order is reflected, Lordship.
In the last occasion,
Okay,
Justice Kalita.
service, no, it's only complete, huh? Nothing more.
My lord, but the service has been completed in the month of February, if I'm not wrong.
Okay. Okay, had Mr. H.K. Jammu, Land Council for the petitioner staff. Also had Ms. L. Hadu, Land Additional PP for the state staff. Huh? The service upon the respondent number 2 is completed, however, none appears on behalf of the respondent number 2 staff. In view of the above, this court deem it proper to appoint one legal aid counsel to represent on behalf of the respondent number 2 staff. Accordingly, Miss, who else is present? Legal aid counsel, anyone? Anyone? No one.
I mean,
Legal aid counsels are, I think, in this court are dying. Even
My-
after appointment also, no one appears.
Yes.
It appears everybody has so many cases and not interested in any pro bono.
My lord, we have applied, but I think it is not yet done.
Oh.
Not for this particular case, but I've also applied.
Mm-hmm.
But the date was extended till 25th, I believe,
Mm-hmm.
due to server problem.
But another problem is majority of the legal aid counsel are not regularly paid.
Not regular. That is why I'm saying dying.
Therefore, the next
This-
time, if appointment is to be done,
Has to be from the High Court.
And moreover, Lordship, they are engaged in the UPI court, Lordship.
Right court.
Some of them, they are engaged in PP also here, there, Lordship.
But then from the High Court, someone to the High Court, actually almost everyone except for the one who is very, very, really busy. Even if they busy also for further, see the pro bono service, these are necessary actually. These are asked actually. Whether what pro bono service have you done, all these everywhere. You will not be able to claim. Hmm? That you are doing something, some service to the society also. Hmm?
H. Jiram, Hinti Jiram.
Hmm?
H. Jiram is also named Hinti Jiram. She used to come in court.
Okay.
Lordship.
Okay, accordingly, Miss Hinti Jeram.
Yes, Lord.
Jeram or J?
Jiram, Jiram. J-E-R-A-M. Yes.
H. Jeram.
H Jeram. From the the panel of legal aid counsel is appointed as legal aid counsel to represent the respondent number 2 informant. Staff. The record we have received the record.
My lord, it is reflected in the cost list, TCR.
Isha is already
Okay.
there, Lord.
Since the then you serve copy,
My lord, I'll do,
Okay.
my lord.
Mr. Jamo, will serve a copy of the petition to the appointed legal aid counsel, Mr. H. Jera. Within 3 days from today.
My
Okay,
lord.
staff. The record reveals that the trial court record has also been received. Staff, in view of the above, let this matter be listed for admission. After,
1st of July,
okay, 1st of July,
my lord.
okay, is it open?
What's that?
1st of July,
It's
okay,
Wednesday.
okay.
Highly obliged, my lord.
Let's
Right.
pray for list this matter on 1st July.
Matter number 13,
Mayor, Your Lordship.
Yes, sir.
Your Lordship, I have filed one IA today
Mhm.
seeking some time for filing a rejoinder with regards to their affidavit in opposition filed in 105. This morning I have filed.
Okay.
my lord,
What this morning you have filed?
I have filed an IA seeking some time
Okay.
for filing a rejoinder,
Okay.
as they have filed an affidavit
This
in
morning?
this morning, yes, Lordship.
There's one adjournment petition is also there.
that has been filed by us, my lord.
Oh, that is filed by you?
Yes, my lord.
Okay.
My lord, I have, my lord, strong objections on that point, my lord.
So for filing rejoinder,
Rejoinder, my lord.
why?
As because, my lord, as per the prescribed procedure,
Hmm.
my lord, there is a certain time limitation, my lord.
Mhm.
It has to be, my lord, filed within such stipulated period,
Hmm.
my lord, even if, my lord, another, my lord, my objection raised in the, my lord, the objection, my lord, in the IA. My lord, firstly,
For the respondent, yes, you are applicant for
Applicant stroke return candidate, respondent, applicant stroke respondent. Also had Mr. M. Kato, Lana Council for
the election
the
petitioner.
respondent election petitioner staff, By by filing this interlocutory application under order 17 of the CPC, the applicant seek for adjournment of the matter on behalf of the election petitioner. Stop. Mr. M. Kadolane, counsel for the respondent, raise objection. Stop. However, considering, upon hearing and considering the fact and circumstances of the
My
case.
lord, Perrier of the matter, the only respondent.
The
It is only Perrier on the part.
this I dispose then? Yes, okay. The I stand disposal, okay?
And my lord, my IA
And
may be-
then in the IA, huh? Who'll say in the IA? Fix, because this is stand disposal.
my lord.
Yes. Okay, hard. Here also the applicant is same, huh? Okay. In view of the order pass today in IA 107, the case stand adjourned to be listed on 8. Okay, 8 June.
My lord, my IA may be, my lord, the disposal.
Which one is
My
your IA?
IA 107, my lord.
10?
7, my lord.
Who's 107 is yours?
Yes, my lord.
Okay. This is what, your petition?
Yes, my lord.
Okay.
That may
The
be,
adjournment petition is filed by you only?
yes, my lord. That may be.
Then why you are objecting?
No, my lord. I am not objecting. My lord, my lordship may kindly, my lord, grant adjournment, my lord, time may be granted, my lord, in this IA, my lord.
Okay. Which IA?
In 107, my lord.
107?
Yes, madam.
107 is only adjournment petition only?
Yes, madam. That may be considered,
No,
madam.
the name may be changed, huh? Then here,
This is separate IA, my IA, madam. In main case, madam.
Main case, me,
in the main case?
yes.
Yes, madam.
Okay. Then this is the change the party. Here,
This is, my lord, Nyamar Karbak, election petitioner.
Kato for the election petitioner, huh? And for the respondent, okay? Then in the main right, huh? In view of the order passed today in IA 107, list this matter again
8, madam.
on 8, okay? Then in the IA, in the IA 105, okay? Have you filed objection?
Yes, madam. We have already filed. In both the IAs, my lord, we have already filed
Okay,
objection petition, madam.
okay.
Objection.
Hard, Mr. And here they are, applicant, huh? Mr.
Raksap.
Raksap, counsel for the applicant. And Mr. Kato for the respondent, election petitioner, huh? Staff, huh? Who submits, just a minute, huh? Objection, okay. Who submits that he has filed objection, and Mr. Raksap Learned Counsel for the applicant also acknowledge the receipt of the objection filed by the respondent election petitioner staff. In view of the above and as agreed upon by both the Learned Counsel for the party, please this matter on 8.
Well,
Okay. Yes.
My
Same
lord,
in the same in 155
my-
also.
my- yes,
Yes.
my lord.
Hmm.
Yes, my lord. My lord, may kindly observe
So-
one thing, my lord. My lord, the endeavor shall be made to dispose of this IAs, my lord. It was filed in the year 2000.
Don't worry, it will be disposed on that day only. It will not be, since it will not be listed before any other judge.
Yes, my
So
lord.
on that day, it will be disposed. Okay.
Highly obliged, my lord.
Deeply
Okay.
obliged.
Deeply obliged.
Item number 14,
Yes.
Yes, my lord. My lord, matter may be fixed in admission column, my lord. In the meantime, we will file our reply, my lord.
Heard Mr. T. Junior, Learned Counsel for the petitioners. Also heard,
The other man.
Ado. Learned Counsel, appearing for the first time.
No, my lord.
Earlier also appeared already. This is CRP 88.
Yes, my lord.
Okay, you appeared. Also, Mr. Diado, you have not yet filed.
Yes, my lord.
Okay. Are you praying for some time to file what?
File a reply, my lord.
Okay, Mr. Ado, Learned Counsel for the respondent. Prays for, how much time is?
2 weeks.
Father, 2 weeks time, 2 weeks time to file affidavit. Counter affidavit, huh? The affidavit in opposition. Stop age prayed for, comma, list this matter after 2 weeks. In the meantime, the respondent shall file this affidavit. Whether the record, have we received the record? Okay. It appears that the record, trial court record has not yet. No, just a minute, there is something regarding transmission.
You
Okay, so these record has been transmitted to the Court of District and Session Judge. The case is pending, was pending before whom, which court?
No, Your Lordship, we have challenged the impugn order passed by the Learned Appellant Court, Your Lordship. That is the CGM Court, Alo, Your Lordship.
Okay, and then it says, it appears that the CJM Court Alo it's a civil case only.
Yes,
It's a civil judge. Civil judge has transmitted the case record before the session,
we are not aware. of
district
this
court.
Because there is no any application pending before this district court.
It's a civil appeal, probably they have filed a civil appeal or what?
No, we have filed an appeal before the Learned CGM Court challenging the Kaba order, Your Lordship. And then before this honorable court challenging the order of,
Have you filed,
No, no, no.
no, nothing such.
then why it was transmitted to the district court?
We are unaware of that, Your Lordship.
Just a minute,
Yes, sir.
regarding transmission. But the Preston is informed me that the entire case record of civil appeal number 17,
Yes,
Dodam Kamduk versus Damle has been transmitted to the Honorable Court of District Judge. Right, on 1924. You have challenged which order? 22. The 24, 524. A copy of which is, okay, from there, passed by civil judge. After that, they have transmitted.
yes, sir.
24/5/24, and this was transmitted on 19/12/24. A copy of which is under. Why it was transmitted?
Your Lordship, we had on the earlier occasion, if Your Lordship will come to page number 44, Your Lordship. On earlier occasion, we had wrongly approached before the district court, Your Lordship.
That is why.
Mm.
That is
However,
why it has not yet returned, it appears.
no, Your Lordship. However, the matter was then transferred to the CJM court. Your Lordship will find at page number.
December 19 24. File code record. No, entire record was transmitted. Because what is CA?
Your Lordship will see at page,
Civil appeal.
yes, Your Lordship.
Okay, C appeal, that was also civil appeal 17.
Yes, but then,
Okay,
since
in
there was-
connection with that only it was called for.
No, Your Lordship. I'll just explain to Your Lordship. Lordship will see that on the earlier occasion, we has approached the district court, Your Lordship. However, subsequently,
No.
it had come to the knowledge of the party that it was a wrong forum, and thereafter we had come before the CJM court. Your Lordship will find the impugn order in IA, Your Lordship.
Impugn order in IA,
Yes,
where?
I filed an IA, Your Lordship, which was,
No, IA is not available here.
no, it's IA is available.
This is what? IA for what?
IA.
Condonation.
Yes, Your Lordship will, in the main petition, Your Lordship will find it page number 105.
Hmm.
105. This is the impugn order that we are challenging.
It's not.
On the earlier occasion,
Is this the order?
yes, on the earlier occasion, we had filed before the wrong forum, and therefore subsequently it was withdrawn, and the entire matter was transferred to
But
the,
this is judgment.
yes, impugn order, judgment and order, Your Lordship.
Okay, no, that is why. Being aggrieved, you file civil appeal before the district court.
Yes,
And then for the purpose of disposal, probably in the first order,
Hmm.
record was called for.
Okay.
Record was sent to the district court. And from there, although you have withdrawn,
Yes.
and then you have filed here the civil revision petition, but then the matter, the record they did not receive. They are yet to receive the record back from district court, it appears.
Yes, yes.
Hmm. Okay.
Must,
They will receive now probably by, since you have withdrawn, probably order must have passed in that withdrawal order only to send back the record.
Your
Let
Lordship
us wait for some
Your
time.
Lordship, yes, Your Lordship may otherwise,
Cannot call from there because it will, must have sent.
yes,
back.
Your Lordship. Well, we can wait for the
Hmm.
order.
Okay, so, list is matter after 2 weeks. In the meantime,
Yes.
the respondents will file their affidavit.
Your Lordship, there is an interim order, Your Lordship.
Okay. The interim order passed earlier shall continue till the next date of this thing. Okay.
DPO.
Matter number 17.
Yes.
So in this case, one LAC is appointed person. However, I have instruction and she told me that she has difficulties, personal difficulties today, so matter.
Difficulty means appearing today.
Yes,
Okay.
LAC.
Had Mr. G. Ingo, Land Council for the revision petitioner, who informed that the Land Legal Aid Council appearing on behalf of the respondent has expressed her personal difficulties today to appear, and therefore she requested the petitioner to seek for adjournment on her behalf Staff one. Is prayed for, list is matter after 2 weeks. Okay.
Interim is there.
The interim order pass RDR shall continue till the next date of listing. Okay.
Development.
Matter number 18,
Hmm. No, make it that, huh? Make it earlier order. However, the legal aid council has he stated to have been in some personal difficulties today, therefore sought for adjournment. Huh? The prayer is allowed. Okay. This is matter after 2 weeks. Interim continue. Okay. Yes.
Your Lordship, here in this case, it has been charged sheeted now, so therefore I pray that a TCR may be called for.
Okay.
Yes, Lordship.
Heard
Copy of
Mr.
DCR may be called for.
Mr. M. Kambo, line counsel for the criminal petitioner. Also heard Ms. L. Have, line Thomas, additional PP for the state. It is submitted that the case has already been submitted into charges. In view of the above, let a trial court record be called for. Scan copy of the trial court record be called for. Staff, list is matter after 2 weeks.
Lordship.
Yes. Okay.
I'd like to.
matter number 20,
My lord, I'm appearing for the appellant at item 20. My lord, if my lord's permits seeking accommodation for today, I would like to appear physically. So I'm seeking it 2 week times. My lord may be granted. Because there are some judgment which we like to place also, my lord, so it'll be quite difficult through VC.
Okay.
today it was taken by them only, Your Lordship.
Okay.
They are saying they have difficulty.
Could have informed the,
Yes.
you are for the respondent?
Yes, yes.
No.
The dependent
I'm
number
for the
one.
appellant.
Okay.
And
You are for appellant?
Yes, my lord.
Yes.
They are for appellant?
in the case, Your Lordship, it will be fixed
Could have informed the other side that you are seeking adjournment
after 1 week, Your Lordship.
after 1 week.
My lord.
Okay. Had Mr.
T. Margar, my lord.
T. Marga, line counsel for the petitioner, who submits that he would not, he is not fully prepared today and therefore sought for short accommodation. Staff, Mr. Who is for Mr. T. Jenny? Sorry, Ms. T. Jenny, line additional PP for the state. Mr. You are for respondent number?
1.
Okay.
Dependent number 1.
You are for 1.
Yes, I'm for 1.
Okay. Mr. K. Taja, Learning Council for the respondent number 1. Jenny for respondent number?
Well, I'm for the respondent number 5, 6, and 7.
Okay, Jenny for state respondent number
And for the,
2, 3, and 4.
yes, Your Lord.
And Mr. Kato for Mr. M. Kato for respondent number 4, 5, and 6.
5, 6,
5,
and
6,
7, madam.
and 7 are also present and has no objection to the prayer so made by the Lana Council for the petitioner staff in view of the above and as prayed for, list is matter after a week.
A fixed date will be given, my lord. So
Your Lordship, I let it come in the new September.
Your Lordship, since he'll be personally appearing, if any convenient is from the appellant side.
either Wednesday or Tuesday, Wednesday, Thursday, my lord. Barring
When? Give that. What Tuesday? Which Tuesday?
Second, that is second week, Your Lordship.
Okay, June.
Second,
9 is see DVD. 10 June.
10, my lord. 10 Wednesday, my lord.
Okay.
Highly obliged.
Start.